Okay, it's 5 o'clock. I'd like to call to order this July 12th meeting of the Albany County Planning and Zoning Commission. So, you may see I'm a bit visually compromised here, so if you're waving your hands and you don't get an immediate response, feel free to jump up and down, scream and yell. We'll get it all figured out. So, first item of business, we can call a roll. Let's do that in seniority order, which would be standing here. Ms. Carnick. Class absent. As you said he would be. Ms. Robert David is also absent today. Is here, so we have a bare quorum, and we'll see how this goes. We may want to have a brainstorming session rather than bringing things to a conclusion. If there sounds like it would be a close vote, I'm reluctant to make any large decisions on a narrow vote of just the three of us. So let's see how that goes. You have the agenda that was distributed with the packet. Were there amendments to the agenda, either in terms of content or order? Hearing none, is there a motion to approve the agenda?
So moved, Mr. Chair.
Is there a second?
I'll second.
Second for discussion. Hearing none, all in favor say aye.
Aye.
Aye. The agenda is approved. Okay. We have minutes from the June 12th, our regular meeting last month. Were there comments on that? Comments, suggestions, corrections on the minutes?
I missed the detail that we had last month. We said there was comments that discussion was had, but I find it helpful if we have a little bit of context about what the discussion was. But I didn't have any comments on it.
Oh, that's a moving target. I think Joe hears it coming and going both ways. I hear. And it is a battle to get the minutes just right. I certainly appreciate more extensive minutes, but it does take staff time to do that, and everything is recorded. But it is certainly helpful, particularly for those who are trying to remind themselves or weren't here what went into the minutes. So,
and maybe some months it's not possible because of the workload. Yes.
Fair enough.
When it is, I appreciate it.
But yeah, the more comprehensive the minutes, certainly the better. And I had no comments or corrections. Is there a motion to approve the minutes then as distributed?
So moved. Second.
All right. Seconded. Further discussion of motion to approve the minutes. Hearing none, all in favor say aye.
Aye.
Opposed, same sign. Minutes are approved. Disclosures, conflicts of interest. Ms. Hannon.
I have no disclosure.
I do have agenda. So that moves us to the paddocks, a regular application. Formally, this is a public hearing, so I would remind folks that the order of events will be receive a presentation from staff as to what is on our agenda. Then we'll invite comments not required from the applicant and ask that Mr. Evans stand for questions. Then we'll take formal public comments by way of the hearing. Please confine your comments to the subject at hand, which would be the paddocks, and we ask that you confine yourself to about 3 minutes. Noting for the sake of the public that may be here for other topics that we have an open-ended comment period at the end for non-agenda topics. So we ask that you confine yourself to the subject at hand when we get to that point. Then we will close the public hearing and proceed to dispose of the application as we think best, as we acceptance, denial, tabling, acceptance with the conditions and whatever. So with that, let's hear from staff as to what it is we're being presented today.
All right. So the applicant is John Evans. Owner is Neptune Management Corporation. The request is approval of a final plat. Current zoning is urban residential. Project summary, the applicant is proposing to create a 29 lot subdivision within their 371.7 acre tract. The preliminary plat subdivision was approved in 2019. Water will be provided by the South of Laramie Water and Sewer District. Septic systems are being proposed for each lot. Per the plat, all sewage must be treated by Presby Environmental Advanced Enviroseptic Systems to a total nitrogen level of less than 30 ppm. Equivalent sewage treatment units may be used only with the approval of the Paddocks Improvement District and the Wyoming Department of Environmental Quality. Storm drainage report was complete for this proposal and reviewed by Bill Gorman, County Engineer, during the preliminary plat stage. Utilities, power is provided by Rocky Mountain Power, internet and phone by CenturyLink, gas by Black Hills Energy. All utilities must be installed underground. Postal service can establish delivery. Cluster boxes must be installed and maintained by the developer. Roads, 2 interior roads are being proposed that will end in a cul-de-sac. Artillery Heights Road will intersect with Bastion Road, a private road, which then connects to City Ranch Road, a public road maintained by Albany County. Arsenal Court will intersect with Artillery Heights Road. The maximum length of a cul-de-sac is 600 feet unless the lots are 1 acre or larger, and the Planning and Zoning Commission approves of a variance to this standard. A recommendation of approval of this application is acceptance of this variance. Access, the applicant has provided an approval from YDOT for the original access permit to the paddocks at Fort Sanders. Second filing, first edition. In between the approved access and the paddocks at Fort Sanders, second filing, first edition, there is an approved access easement now known as City Ranch Road, a county road. Bastion Road is a privately maintained road that is dedicated for public use, as are all roads through the paddocks subdivision. Road maintenance, the covenants that have been presented to the Albany County Planning Department intended to be applied to the paddocks at Fort Sanders, second filing, second edition, are the exact same covenants in effect for the paddocks at Fort Sanders Phase 1. A new copy of the covenants will need to be notarized, signed, and filed with the Albany County Clerk. Road maintenance is discussed in the aforementioned covenants and will be taken care of by the Paddocks Improvement District. Fire protection for this area is provided by Albany County Fire District 1. The applicant is required to provide a water source approved by the fire district, and the applicant is putting in fire hydrants. There were some reviews. The assessor's office, Chelsea Matthews, had no concerns. Engineer Jake Schneider had concerns with the final plat, engineering for construction plans and water line construction plans. Those concerns have been taken care of. Albany County Fire District 1, Luke Hawkins, chairman, has concerns about the ingress and egress. His full comments can be seen in the review section. Albany County Planning, Jordy Umberzat, GIS analyst, has no problems with any of the road name proposals. Road and Bridge, Rob Fisher has concerns about the approach from City Ranch Road. Holly Dyer from the Laramie Rivers Conservation District talked about soils and vegetation, erosion and weed encroachment. Her full comments can be seen in the review section. And YDOT Taylor McCourt has no comments. A little bit of history. In 2008, a preliminary plat and phase 1 of the final plat for the paddocks at Fort Sanders was approved. In 2019, a new preliminary plat and the paddocks at Fort Sanders second filing, first edition final plat was approved. Staff analysis, the applicant has provided a complete final plat application, including all required documentation and reports. This application is the second edition of the paddocks at Fort Sanders second filing. Lots would be accessed from Bastion Road via City Ranch Road. There is still a concern about having only one access in the paddock subdivision. However, the county has not adopted any regulations to implement multiple accesses. At full build out, the paddocks will have 2 access points, Bastion Road via City Ranch Road and Garrison Lane via Howe Road. Findings of fact, the findings necessary for approval, applicant responses, and staff analysis of inclusion of required information as referenced in this report are affirmatively adopted as findings that the applicant has provided the board with adequate information, that the requested and required findings, documentation, notice, and notations have been satisfied by the applicant, and the same are incorporated herein. Inclusive of law, the applicant is proceeding in accordance with and is in compliance with the requirements of the Albany County Plating and Subdivision Regulations. And staff recommendation is to approve the paddocks at Fort Sanders, second filing, second edition subdivision application SD 1322, adopting and incorporating the staff analysis, findings of fact, and conclusions of law as each are stated in the staff report.
Right. Let me ask just a threshold question before I open it up to general discussion. It's one that I emailed to Mr. Harris and Mr. Gertz earlier. What is the kind of regulatory status of this, given its long history? It has spanned a whole variety of changes in our subdivision regulations. So what is our decision space at this point, having approved the preliminary plat some years ago?
So it's the same preliminary plat. The final plat was turned in November of last year. So the final plat regulations were applied under the final plat regulations of November of last year.
So under the current regulations, there are certain, we moved a lot of stuff into the preliminary plat. I guess is kind of where I'm probing around, that we make decisions on before we move to the final plat.
These are under the old regulations.
And so tell me the difference between the old and new regulations with respect to paddocks.
You got an answer for that.
All right, maybe they'll come out over the course of the discussion.
I mean, what are you looking for?
Well, for example, we talked about the chapter 23 groundwater impact studies, which we, under the new regulations, we would have taken those care of all those long before we got to this final plat.
Mm-hmm. And they have been taken care of for the preliminary plat of this application. They have received a non-adverse recommendation from DEQ. And I mean, this is in line with the preliminary plat that was approved. So that has been accomplished.
Okay, well, maybe we'll come back to that. All right, let me see if anybody else has questions on the staff report.
Joel, why were you sitting down?
I didn't know how long Matt's answer was.
I have a number of questions for you, Joe.
Let's hear it.
Well, first of all, just the low-hanging fruit, the variance for the cul-de-sac.
Sure.
That's still needing to be a part of the approval, and right now it's not in the script. So is that something that we
Yep.
get there?
Well, yeah, with approval of the application, you would be approving this.
And do you know why the length was 600 feet?
I don't know.
Is there any
That's just
public
what our
safety
regulations are.
reason?
I'm not sure why it was.
Yeah, this is what it's been since I've been here.
Okay, so I guess moving into more complicated territory. Well, first of all, the 36-month requirement to keep coming in for your next phase, that's all being met, right? That all the 36-month
That was
requirements.
not a requirement on this one.
Oh, that's the new regs, that's not the old regs. Oh, very good to put that in. Okay, so that's, so the current statements on the preliminary plat regarding the Presby systems, the 2.5 feet distance between the bottom of the absorption field and water, that we don't have to carry that through to approval of the final plat.
That was required by DEQ.
But the DEQ, we've been told, is a recommendation that we can take it or leave it. Because I'm just curious where the 2.5 feet came from, because our county wastewater regulations require 4 feet separation. So I'm just wondering why was a less separation allowed in this case?
So Mr. Chair, Commissioners, if it's less than our standards, they'll still have to meet our standards. So if DEQ says 2.5 is okay and we say 4 is okay, they have to go by the more stringent standard in that situation.
It just seems confusing to have that be labeled on the plat to allow for a lesser standard that the county.
It wouldn't allow, just because it's on a plat doesn't allow, I mean, we still have to follow our regulations, so we wouldn't go lesser than what we require. I mean, it doesn't make sense to have it on the plat.
But if it were to change back, then it would have to follow that, or change in a different way. Like the county doesn't require it, then it would still be on there that it would have to be 2.5 feet.
But if we're allowed, if we've been told by DEQ that the chapter 23 letter of, or adverse finding or non-adverse finding is a recommendation that we can take or leave, then when it comes to designating what goes on the final plat, we as a body can propose a different labeling of the final plat.
Well, let me first answer the first comment, I guess, that we could take or leave. We have to at least, so if they provide a non-adverse recommendation, that's something, that's saying they're good with it. So, right? So going from there, they're good with it. We don't have any problems, right? So we can kind of, I mean, we have to kind of go along with what they say. I mean, we should go along with what they say because that's what they're approving, right? Now, if they gave us an adverse recommendation, we can kind of take and leave it, but there's certain things that we have to do if we leave it. If we say, you got an adverse recommendation, the Board of County Commissioners are required then to say, we're not following DEQ, and you have to put that on the plat that we're not following DEQ. And any offers or information that goes out for sale, we have to say, we're not following DEQ. So anybody that decides to buy it knows that DEQ gave it an adverse recommendation, and then.
And we said those words.
Right, right. Now, I mean, DEQ's provided those recommendations for those notes. We've never had a situation where we wanted to go above what they have said. So I guess, I don't know, I mean, we do have, I guess, have some discretion. I mean, I think if we did put something on there that was more stringent, I think we should at least note that DEQ has recommended that this be put on the plat. However, this is what we're going to require and put that on the plat. So that we still have their information on there. I don't know. Maybe Matt can shed a little bit of light on this, because this is a weird situation, you know. If our regulations are saying it's 4 feet and then 2.5 is what they're saying is okay, it doesn't make a lot of sense, right? So.
Yeah, let's hear what Harris has to say.
Really, you know, under the old subdivision regulations, which are controlling in this case, it was not terribly clear, you know, at which stage each requirement applied, like we have it set out now. This, I would advise, is not the time to re-adjudicate the DEQ non-adverse recommendation. There is a binding requirement that they have Presby advanced systems and are on south of Laramie district water. And the preliminary plat was approved. So there already is a binding statement from the commissioners that it has been approved. So as long as this final plat proposal is in line with that approved preliminary plat, this commission does not have the opportunity to go back and revisit the DEQ issues.
I'm all for the Presby or the reduction of nitrate to 30 milligrams per liter, and I'm all for this municipal water. But I find it's inconsistent to allow a 2.5 foot distance between the bottom of the absorption field and groundwater, because it's sort of a national standard to have 4 feet, because it's been found you need 4 feet to remove bacteria and viruses, which the Presby system is not. It's not going to touch viruses and bacteria. So to protect public health, we really need to have the 4 feet. So if it's as simple as adding on to the plat, making sure people understand that notwithstanding what DEQ says about 2.5, the county regulations are going to require you to have 4. It seems like that's confusing to the potential homeowner, that they think they can come in and put in a system that doesn't provide that 4 feet of distance.
Well,
The wastewater would still have to go through all of our processes.
So,
And
Mr.
So it
Gooch,
gets caught there.
would, so it is requiring the county regulations for small wastewater system permit require 4 feet.
That's what I'm actually looking at, 'cause I want to make sure that that's the case, but.
So if that is the case, then there's no world where they wouldn't meet whatever the county small wastewater permitting regulations require. Otherwise, they would not get a wastewater permit.
But Jim Hinges, the point is we put all this stuff on the plat with the notion that people read the plat. I mean, I think that's highly suspect, but that's the whole idea is that that's where it tells you that the water doesn't meet certain standards or there was a non-adverse. The fact that we have approved the preliminary plat and the DEQ recommendations, does that preclude us from adding to that? That seems odd. You're suggesting we cannot go back on that.
Saying,
Are
well,
we forbidden to add to that as we proceed with the final plat?
if it's clarifying, yes, but I'm talking going back and just redoing substantive kind of approvals.
Okay.
That's different than possibly asking for a clarification in language on the plat.
Okay, I believe what Commissioner Henning is
Okay.
suggesting is pure clarification, yes.
Okay,
Yeah.
well, we will need to find out what the county standard is, I think, before we can provide a clear answer.
It's on page 7 of 48, I think, under the design and construction.
Okay.
But anyway, also along those lines, I was sort of alarmed that the decision to replace Presby with some equivalent system was left to the homeowner association and DEQ, and the county is sort of cut out of that decision making. But I guess really they're not, because they'd still have to go to the wastewater engineer to get approval for the system.
Correct.
Okay, all right, well, I'm ready to move on to traffic concerns
All right.
now, if you are.
Yeah.
Okay, so it seems like a pretty big problem in this plan that the Albany County Fire District 1 has brought up. And to the point where they're hiring an attorney to write to the county about this oversight in the plan. So I'm concerned about being negligent on addressing emergency responder and homeowner safety. And when I am looking at the platting, the platting and subdivision resolution, you know, it says its purpose is to promote public health, safety, morals, and general welfare of Albany County. And it goes on to talk about in chapter 1, section 5, relationship to other resolutions or laws. And it talks about how if there's municipal, county, state, or federal law or regulations impose additional standards on land use, the more restrictive standards apply. And the attorney writes to us that when you look at the International Fire Code, the 2018 International Fire Code, that's what should be followed here. And that is incorporated by reference in Wyoming statutes for the fire marshal. And so it seems to me that there is a more stringent statute that applies to ingress egress for firefighting in this subdivision, and I think that's a problem right now to not address it.
So I certainly understand the sentiment, but I think that should also come with the caveat of it has to be a law which is applicable to the subdivision application and has, you know, jurisdictional effect over what's being proposed. There is nothing with the state fire marshal about review of subdivision permits that I'm aware of. And we have not incorporated that as a county. It would be the same as saying, well, this is what the city of Laramie would require, which is a more stringent standard, so we're going to apply it in this case. We could not. Their standards have no jurisdiction on this.
Even if you look at it as this relationship to other resolutions and laws, I mean, that if the fire marshal in statute 35-9-107, duties and powers of the state fire marshal, they incorporate by reference the International Fire Code. So I mean, all sorts of statutes incorporate, like the electrical code by reference, the plumbing code by reference. It seems to me that this is being incorporated into the state statute as something that the fire marshal has the jurisdiction to demand. And also, when you just look at the spirit of the existing regulations, I know they don't explicitly talk about access, and I know that's a reg change that you're putting forward to address this problem. But everything that you read in terms of the spirit of fire protection is to be protecting the first responders and the residents. And so I guess I have to take our attorney's advice on this, but I find it troubling that we're asking for comments from the county fire district, but then you're able to just disregard them, especially when it's as serious as having adequate ingress egress for first responders to keep them safe, let alone the residents escaping in some kind of logical way out of the subdivision if there's like a grass fire that sweeps through. So it seems like a troubling aspect to this application that it's not satisfactory to me that we're not able to address it somehow.
I certainly understand the sentiment, but I don't see any mechanism where we can carry that over. It's
So-
not a standard that we have.
Can I ask a question then? In the case of the Wild Horse Ranch, I know that was a zoning change, not a subdivision application, final plat. But in that case, it was a similar concern about the safety of the first responders by turning a property from residential to commercial. And the county commissioners rejected that. And I think it was based again on the concerns that the first responders brought up. And I just wonder what was the basis for that rejection, and does it apply in any way here?
Yeah, Mr. Chair, Commissioners, my understanding of that, I don't know if it was necessarily a fire concern. There was really, I think it was just out of place. I didn't feel like it was part of the, fit in the character of that surrounding area. From my recollection, that was what led to the denial of that application. But, it has been a while ago, so.
I'm going
Yeah, I
with
don't-
how the boomerang reported it. So-
Okay, well, and that may have came up, so I think there were other issues too that were brought up as well. So, yeah, I'm kind of, because I'm trying to, that commercial land use or the change to the zoning there. I mean, it would have had good access to the highway. And so it wasn't like it wasn't hard to get to or anything. I know there was some discussions about, getting access in the subdivision, the roads and things, but that had nothing to do with the county. County couldn't even regulate that at the time that became a subdivision. But yeah, so that was probably part of it, what you're saying. I just don't remember the full scope of the denial. But I can kind of look it up, I guess, and see if there's any other information you bring towards that. So.
I'm sorry, I'm monopolizing all the questions.
No, go ahead, but let me just quickly jump in there, there's an opportunity since the planning director is up. So submitted for review, we've got some, 15 different agencies. I think our intuitive understanding is that we submit those reviews and we do something in response to them. So what of that long list has any regulatory follow through or authority? Are those all purely advisory? Are we, and we've talked about requiring fencing or fencing off wetlands and so forth over the 2 years whenever I've been on this commission. We have implemented some of the recommendations as conditions for our approval. But in general, why are we asking for all this advice if we are not empowered to take it?
Right. I mean, and that's a good question. You know, the subdivision standards, the statutes actually, they require that we request information from the Laramie Conservation District, Laramie Rivers Conservation District. They also, I believe, require a request from the fire folks, I believe. But the statutes, one, they don't say what you do once you get the the recommendations back from them. I think what we have to do is we have to review their recommendations, their comments, and then determine whether they apply to any of the regulations that have been adopted by the county commissioners. So we would have to, I mean, that's what we do. We look at what they say, and if they apply to the standards that we have, then, then that's what we do. I mean, if there's not a standard that's been adopted in the subdivision regulations, it's hard to include those things in these regulations. Now, zoning is a little different story. I mean, especially if it's like a conditional use permit or, zoning district amendment. I think there's a little bit more latitude in those permits, but subdivision, it's pretty much check the boxes, and that's, for the most part. I mean, there's probably a little wiggle room, but we just have to tie it to something that's a standard that's explicit in the regulations.
Maybe we put that on a training session for ourselves. I think that does seem odd to all of us that we're soliciting this advice. And in some cases, our respondents are going to some effort to give us their very best recommendations, whether it's wildlife management or traffic or fire control. It seems minimum disrespectful of them to say, yeah, thanks.
Right.
Can't do anything with it. But if that's the case, then that's the case.
Well, and one of the things I would point out is that we are working with the fire district, and we have worked in the fire district in the past, specifically that organization, because, fire suppression and, safety in the county is really their concern, and we want to work with them to make sure that we're, coming up with regulations that are useful for them. For example, one of the things that has changed in the not too recent past or whatever is the use of cisterns. While there's still an option to use a cistern through changes in the regulations, now there's a little bit more leeway because the fire district can say, well, instead of that, we would like to provide you to do this so that we can provide water and whatever needs to suppress the fires or any fires that happen. And they have now a kind of a program where the subdividers will pay into it's a hauled water program is what it's called. And that money then goes to buying pumpers and all those different types of trucks that they can buy. So that they can use that as the mechanism to bring water and suppress fires and things, instead of just planting a cistern in the ground that no one was really keeping track of or making sure it was filled, and sometimes they didn't even know where it was at. It just became easier to defer to the district to work with applicants to do that, and for the most part, most applicants do that. they want to do that. They want to pay into that so that they can have better fire suppression and such in their subdivision. So I guess with that too, we are currently, and you may see in your agenda, we'd like to talk about access, because that is obviously an issue that has been coming up over and over. And we have received comments from the fire district and homeowners and everybody else about that. So that's something that we're working on changing. Unfortunately, that's not something we have changed at this point. And so yeah, but yeah, to answer that and to, comment on Mr. Hinckley's comments, I mean, we should consider these comments and see, if there is some latitude or if there's some things we need to tweak in our regulations so that we can use this information that we're getting from these agencies that are, they're professionals. Our Rivers Conservation District, they know what they're doing. They're all professionals. The fire district, these guys, that's what they do. So yeah, I think all those are good suggestions. But we're trying to deal with what we're doing now, and not all of that applies today. So.
Stay within the statutes, and we're not granting veto power to all 15 of these, but let us take what guidance we can. Okay, I'm sorry I interrupted your train of thought. I appreciate the detail with which you looked at this. Please go ahead.
Hey, George needs to regroup for a minute. Okay, Joe, while we're on the topic of fire protection, so the hydrants, because they are, because the system is being served water through the municipal system, they have to meet City of Laramie hydrant fire code. And is what's been submitted do that?
I believe Jake signed off on it.
Okay. There seem to be complaints about the existing hydrant system out there in one of the letters we received from the community. So I wasn't sure about the current or the future, but if Jake signed off on the future, then I know he gave that serious thought. So if there's, there seems to be indication from community members from the South Knoll subdivision that residents in the paddocks are using their road but not party to the road maintenance agreement. Is that anything that can be required or encouraged, that because people are creating a second access, apparently, should the paddocks be, should an approval be conditioned to require them to enter into a maintenance agreement for those roads?
I mean, I don't think that we have anything to point to be able to force that.
Okay. All right, now let's go to.
Mr. Cruz, had a comment on that?
Yeah. So, Mr. Chair, Commissioners, Joe's right. I mean, there's nothing in our regs because they have an access, and so I can't say that. Well, you might be using this other access. Now, I mean, you guys can always encourage the applicant to discuss these things with the district, and maybe there's something that can be done there, but we don't really have any. We don't have a hammer to drive that nail in, I guess. So.
Just moving on to more traffic concerns. The concern from Rob Fisher from the county road and bridge. He didn't get into a lot of detail about his concerns, but I think it's a reasonable concern to wonder how. Right now, that turn lane is designed for, I think, just one car to be waiting to turn. It's a 700, based on the traffic study, they say it's a 775-foot turn lane, and it only assumes a storage length of 5 feet, which I took storage length to mean a car sitting and waiting to turn. And now we'd be adding all these more cars. And so I guess one of my fundamental questions is there any ability, probably the answer is no, to go back and look at the 2017 traffic study and whether that is adequate. Are there certain standards for conducting traffic studies? I mean, because what I found to be, to me, a glaring oversight was just to look at the two intersections instead of sort of similarly situated intersections on 287, where in 2020 we had 2 fatalities. And so it's like, shouldn't the traffic study be looking at sort of the totality of how people turn off of 287 in the 65 and 70 mile per hour zones? Or is it normal to just target the 2 intersections of use as opposed to the increased traffic on a longer segment of road?
Sure. So, unfortunately, this falls under our last regs. Since then, we've put in a regulation where we can do a traffic study. We didn't have that ability. The 2017 road study, after we got Rob's comments, I mean, I talked to YDOT a lot, and they stuck by their no comment, no concern comment. So
Did they relook at the traffic study, or did he just go off of his predecessor's sign off?
yeah, so he went through and looked at it and thought it met their requirements for everything. So they stuck by that, and I mean, I have to assume that he knows what he's doing.
Well,
Why not?
I appreciate that you followed up with him a couple
Sure.
more times beyond his email, because the email was sort of seemed like somebody else did it. I'm not gonna look at it
Right.
again. And considering the fatalities on 287, I would have like done a cover to cover look again
Sure.
at it.
And we also had Jake look at it, and he signed off on it.
So, okay, there you go, phone the Jake card again.
But like I said, we have regulations now where we can require driver's license.
Right, so big thank you to our deputy county attorney for all the improvements that you've made to the regulations. Good job. Too bad we didn't do it a year ago. Okay, that concludes my long list of questions. Thank you, Joe.
Thank you. Mr. Cronin, you want to add to that?
I think Ms. Hannon got most of it, but I did wonder about how the assumptions for that traffic study are holding up. Now, they assumed 1% per year increase in traffic, and just anecdotally, it feels like there's a lot more traffic on streets.
No idea.
But is that something that could be looked at, or is that again water under the bridge here?
I mean, maybe call YDOT, maybe they would have those numbers. I have no clue.
They weren't concerned about that when they talked.
Nope.
I mean, not understanding all the engineering stuff, I don't know if it's the traffic on 287 that they really are concerned about, it's the traffic coming onto 287 where that intersection is. I mean,
But it's impacted by people barreling past.
True, and I will note that as part of that study, they did put in a left turn lane, and it improved that intersection, so.
Yeah.
Mr. Chair, I thought of another question.
So
Joe.
yeah, you through?
Yeah. She got most of it.
Okay. Please.
Usually with the 413 pages of this portion of the packet, I might have just overlooked it, but I don't know that I remember seeing a list of adjacent property owners that would have received notice in the mail.
I can find it if it wasn't in there, but
Because the city is one of the adjacent
Yeah.
property owners, right?
it was sent to them.
But, yeah, so they were aware, but they had no comment.
Didn't get any comment.
Okay, thanks. No, I'm really done.
If you've got more, feel free to jump in. And again, my questions to add to this, maybe they're more educational than regulatory. There's a statement in there that the roads within the subdivision are privately maintained but dedicated to public use. If I read that correctly. And I know that's been a point of contention, say in Sherman Hills, there just seems to be a kind of a inherent unfairness to requiring a private entity to maintain roads that all the rest of us could drive up and down willy-nilly. Can you enlighten me on that? Is that standard procedure? Is that was just the deal, and so that's the deal, or?
Yeah, that is a common thing throughout the state. Is that when you're dedicating something on a plat, you do have the ability to reserve it as a completely private road, but I think just because of the very nature of a subdivision, that's not the case. So that's really up to the subdivider, and it's also up to the Board of County Commissioners to actually accept maintenance and responsibility of a road and to make it a true, because there's a difference between public road and a county road. So this is not the latter, but it's not uncommon. It's also all of Centennial is this way.
So were the county to accept the county road, then the county would be taking on responsibility for its maintenance.
Yes.
That would be the difference between what we have here and going to the next step and saying it's a full scale public road.
Well,
Says it is, it's a public road, but the public is not maintaining it. That's correct.
the county is not maintaining it. If the county is the public in that situation.
Is there any sense in which the public is maintaining the road?
They would probably, I mean, the closest thing would be a county road. I guess, you know, I guess I don't quite understand.
Well, I just, again, the thought, I think we would all find it somewhat odd that we have a situation where my neighbors and I are required to maintain a facility for public use. Now, if you're assuring us that that's commonly done, I'm somewhat surprised that it hasn't been successfully challenged, but I'm accepting your representation of how that works. So, all right. That's how we do that. It's like a little surprise. Go ahead.
On the conclusions part of the stormwater study, which is page 7, surprised that they were just looking at a 10-year stormwater runoff. In the life of a subdivision, 10 years is not very long. Is that a requirement that they only have to look at a 10-year storm?
Yeah, Mr. Chair, Commissioners, we have specific standards and or requirements of what is needed for those storm drainage studies.
And that's all that's required?
I believe it's changed since.
It may have changed, yeah. Jake has revamped or went through those standards and changed them quite a bit. Really, our standards were really old, and yeah, even when our past county engineer was here, he wanted to make some changes to those standards as well. So, but yeah, at the time, that's what
That was the standard that this was submitted.
Good. The other thought I had, which I alluded to earlier, and I guess you've now heard the answer at least indirectly, and I see Mr. Ralph on the call here. There were 2 subdivisions last fall, one of which was quite contentious on this issue of the adequacy of the groundwater impact studies. One virtually adjacent to this annex and the other in Centennial. I don't recall the names, I'm sure you would, where this body, despite a non-adverse opinion from DEQ, judged the impact studies to be scientifically inadequate and required the applicants to redo those. Again, it was contentious, but we stood our ground. And I, having been through that, I'm reading the chapter 23 study that was for this study. It has many of the same flaws. Were this starting from scratch, I think it's clear that we would have treated it similarly and required those scientific flaws to have been corrected. Now, maybe no need to elaborate on those. If I look to Mr. Harris, he tells me that horse left the station with the approval of the preliminary plat, is that correct? Okay, so I would simply note for the benefit of those who may be looking at this record, that this would not be an acceptable analysis of wastewater impacts going forward. We are trying to hold our applicants and DEQ to a higher standard going forward. I appreciate Mr. Evans' work to protect the groundwater estate, and he's got a good project going here. But just for the record, there are significant scientific flaws in that we would not allow otherwise. So that's all I had. Other comments, commissioners? With Mr. Evans, would you like to address us regarding your application? Not required to add your thoughts for a little bit.
I guess the only thing I have to add is that all the standards that were applied to this application were what were used on previous applications. And having met all those, we proceeded to sign from that standard. Any comments on the engineering aspect of it? Yeah, we believe that we're in compliance with all the regulations and requirements.
Questions for Mr. Evans? So we'll follow up on the issue of these Presbys in the 30 milligrams per liter. So that same requirement was made of your first filing. And those were installed. I'm
Yes.
just curious, those have worked satisfactorily as far as you know?
Yes, they have been, and they have been maintained adequately, so we haven't had any complaints about that.
Has there been any monitoring? It's curious to me when one reads a requirement that they meet a certain standard. Did anybody go check to see if that standard was met, or do we assume from the engineering of the system that the standard was met?
No, we have had maintenance people who are contracted go out and inspect those on, if not an annual basis, at least on a basis as required by the owner.
Is it required by
The owner of the property.
okay. But DEQ did not follow up that requirement with a maintenance schedule and a reporting requirement.
No, not in that order.
All right, thanks for educating us on that. Other questions? Anything else you'd like to share with us?
I just appreciate your diligence on this. We look forward to going ahead with this project. The same contractor lined up to do the work that did the previous sections. They're very adequately done.
Yeah, I think it's consistent with the growth area management plan and trying to move those higher density developments in a little closer to town and keep it off to the west off the conservation areas. Good job, thank you.
Okay, thanks.
All right. That will get us to the public hearing. You've all heard the discussion so far. Perhaps that will affect your comments, but we're now open to public hearing. First come, first serve. Go right ahead.
Hi, good afternoon, good evening. My name is Michael Peck. I'm the president of the Paddocks Improvement District, and I'm representing the district with my comments. And I actually have three. First of all, I'll mention the septic system. I wasn't going to mention this at all, but the contract to maintain and inspect the septic system, I believe, has been canceled for well over 2 years. So nobody's inspected mine, and I'm pretty sure that folks that have had problems with their septic system that are pretty much on their own at this point, even though that the covenants basically put that responsibility on the subdivision. But my two issues that I'd like to address has to do with access. I'm looking at chapter 5, section 6 of your standard, and it talks about documenting access to public right-of-ways and that. We have, as residents, several concerns with the existing number of lots being able to access through City Ranch Road. And by the way, I've had some really close calls in that turn lane. I mean, I could have been a fatality on that very easily because that turn lane is very, very small. But now we're talking about adding 29 more lots. The solution, or a solution, other than improving the turn lane on 287, would be to allow access to Howell Road. If I go back to the access section, it basically talks about ensuring that there's adequate access, egress to public right-of-ways. Today, we have barriers put in place based on an agreement reached between Neptune Management and the cement company some time ago. If I go back through and I read section 6A, it talks about maintenance agreements being in place to ensure that those access to public right-of-ways are in place. So our as a improvement district, our recommendation would be to withhold approval for any additional construction at PADX until the issue of additional access and egress is resolved, which would be involving discussions between Mr. Evans and the cement company. There is an agreement between those two parties, which may involve committing to doing a certain amount of maintenance on Howell Road. The last issue, it goes back to the same section, 6 Bravo, which discusses updating on the traffic studies. And it specifically talks about if there's more than 20 additional lots, then another updated traffic study might be appropriate. And again, that goes back to the concern that we have as a whole on the number of the ability to egress and degress. And in an emergency situation, if we have a grass fire on the entrance road where there's no way to go, there's no place to go, and all the other exits are blocked, which we feel is an unacceptable matter going forward. And it is a simple solution. But it does involve some negotiation between Neptune and the cement company.
So having heard the representation just from staff that we simply have no authority to look at access issues. Can you respond to that?
Well, I'm reading here in your
challenge their representation.
Well, I'm reading here in your standard, and it says documentation satisfactory to the board that there's adequate access has been provided and that all proposed streets, alleys, and roadways within the subdivision conform to the applicable standards of the resolution. Such documentation shall include evidence of legal access to public roads and any other information required by the planning department to ensure adequate access to and within the proposed subdivision. And then if I go to subsection A, it talks about maybe a maintenance agreement may be needed in order to provide that access to the public right of way. My understanding is Howell Road is a county road, but yet as a resident of the paddocks, we're not able to access it. Now, I did hear about Garrison Road having access to Howell Road, but unfortunately, the majority of us residents, we're blocked to get to Galveston, also to Garrison Road because of a barrier that's been installed. So again, we're all going through City Ranch Road, and it's already congested, particularly in the egress part. And then having more residents is just, it really provides a safety issue in the improvement district's opinion. And like I said, our recommendation would be to withhold approval until it's resolved.
Right, let's hold that thought, see what else we've got from the public. Maybe we'll get staff to respond. Because we're, of course, hearing different things as we sit here.
I'm supposed to ask, is there anybody in agreement in the audience with me on that issue?
Well, we're not taking notes here. We're taking notes up here.
So some folks don't maybe want to get up.
But if anybody else would like to get up, now's the time. Ms. Adler, what are you got? What are you on?
Oh, please go ahead.
Did you want to go out?
Right in.
I have to put my shoes on?
No.
These are obviously issues of interest to this board as well as yourself.
I'm Carol Collier, I live in the paddocks, and my main issue is access. The access, or the turn lanes off 287 totally inadequate if you're headed south, and they're non-existent if you're headed north. If I'm coming from Fort Collins, I hold my breath. And I often will go to Howe Road and Linda Chaparral because it seems a much safer access. There have been times when we have been snowed out of Bastion Road, and they've actually had to unlock the blankety blank gates. It's a totally inadequate situation in any kind of emergency and just normal everyday access. And those of us who do use Chaparral on occasion would not use it if we could get there off of Howe Road. And the county needs to address that issue. Thank you.
Thank you. Not a new issue by a long shot.
Chairman and Commissioners, my name is Susan Adler and we live at 5334 Southview. I live in South Knoll. I sent you folks a letter. I'm not going to read it. I'm not going to reiterate a lot, but I do appreciate your comments. One thing I will additionally point out is my house borders 287. And I will tell you, the traffic on 287 since 2017 has increased a bunch. There's not a minute that goes by that there's not a vehicle going one way or the other. I think it would behoove the county to request another traffic study on 287 for the paddocks. That's all I have.
Others? Mitch, Mr. Edwards.
Thank you, Mr. Chairman, Commissioners. My name is Mitch Edwards. I'm an attorney with Nicholas and Tangeman. We represent Mountain Cement Company. I'd just like to ask that if the commission takes a motion to vote to approve this final plat, that they do so with the requirement that an additional note be added to the plat, which would be note 13. And that is to just simply reference what is in your packet, and that is that all lots are subject to the Hall Road Maintenance Agreement that was recorded on June 25th of 2008 at document 2008-3871, and that all lot access is to be to and from City Ranch Road. I just want to address that a little bit. As was in your packet, the Hall Road Maintenance Agreement addressed this and actually requires at paragraph 3.0 that Neptune agree to amend its preliminary and final plats for the paddocks at Fort Sanders to provide that primary ingress and egress from and to all lots excepting those along Calvary Road and Barricade Road is to be from City Ranch Road. Now, I want to disabuse a few notions that have come up because we've heard that Howe Road is a public road, and it is not. And that's part of what this agreement was addressing, is that Howe Road is not a public road. It's never been dedicated as a county road. In fact, the county doesn't even have easements over the majority of that road. Only the very narrow part that goes from 287 to Chaparral Lane is the only part that the county has any easements over. It is a Mountain Cement's Hall Road, and that's why the document maintenance agreement refers to it as the Monolith Quarry Road. It was renamed simply for mailing purposes for others that had property along that road to Howe Road. So it's not a public access, it's not a public right of way. With respect to the issues regarding the gates, and I know some of the folks that live out there, many of them weren't around at the time, but there was litigation regarding those gates, and the lot owners out there were trying to say that they should not have to deal with the locked gates, that they shouldn't have to go down Bastion, that they shouldn't have to go to City Ranch Road, and they lost that litigation. The court ruled that they were well aware of the requirements and that they were required to go to Bastion Road to City Ranch Road. The second part of that is now some of the folks that were part of that litigation the attorney that represented those folks is now trying to latch onto the International Fire Code to try to suggest to you all that there should be a secondary access. If you look even at Ms. Getz's letter, that letter provides that it's a fire apparatus road. And that's something entirely different that's required. And if you actually look into that International Fire Code, and I believe it's at Appendix D 103 point something, it talks about security and gates on the fire apparatus roads, including swinging metal gates and manual operation and all those kinds of things. Why it's important to reference this haul road agreement on the plat as a note is so that there's no question that folks, even though they may not read it, they're supposed to read it, have notice, and there's no question that they understand that this applies to their property. It's also important because to answer that fire apparatus access, what the agreement provided is that once City Ranch Road was constructed, the post road and the traverse road from Howe into Garrison was to be restricted by a gate accessible by emergency personnel. So that actually is a fire apparatus. Those are fire apparatus roads that the fire department can access in the event of emergency. And so those are present, whether or not the county codes require them to have that. They're actually present, and they're present through the requirements in this haul road maintenance agreement that those roads be gated and secured for emergency access. So we just simply ask that that be placed as a plat note. And I don't know whether or not Mr. Evans is in agreement with doing that, but that's what we'd like to see as a condition to any approval. Thank you.
Thank you. Thank you, Mr. Edwards. Other public comments? All right.
Yes, thank you. I don't want to reiterate what's been said, but I do think maybe you should. Oh, excuse me. I'm Don Rigotta. I represent Paddocks and Neptune Management. I'm an attorney with the law firm of Rigotta, Edwards, and Rapua. In fact, I was a participant in the drafting of this haul road that we're talking about 15 years ago. Permeating the whole discussion about this haul road agreement was safety. And Mountain Cement runs trucks across Howe Road on a regular basis. They're large, they don't stop quickly, they haul a lot of material, and they are a danger to traffic. And when we negotiated the Paddocks, the Howe Road agreement, the covenants, the entire complex, safety was a primary concern. How can we direct traffic in a way that they don't have to compete with Mountain Cement's trucks on a regular basis? And if they did, and if there was a huge amount of traffic onto Howe Road with all of those trucks, it's just a disaster waiting to happen. And from Paddocks' perspective, that's not a safety, that's a safety issue that they tried to address with the provisions with regard to City Ranch Road being the primary access. And what Mitch Edwards said is true. The agreement contemplates access for emergency purposes. If there are issues with regard to emergency access that are not working as well as they could, those issues can be addressed. There are ways that we can deal with ways to open gates and keys and other things that Paddocks and Mountain Cement have talked about with the neighbors. Those are, in my view, extraneous to what's before you today, and that is approval of 29 lots that are consistent with the Howe Road agreement and that provide primary access through City Ranch Road. And I think that Paddocks submitted all the requirements of the county, and would ask you to approve their preliminary plan or their final plan. Thank you.
Other comments? I see you. Lady in the back, please come forward and introduce yourself.
My name is Jenny Christensen. I was just recently, I was the Paddocks HOA president, and now I'm the secretary. So we just had our elections. And I just wanted to kind of echo what has been talked about as far as safety access, as far as some of the comments just made about emergency access with the gates. I mean, without cutting the locks to open the gates, they can't get through easily. There's a couple people who have keys, but how would we get it to, I don't know, emergency responders quick enough? That is something we have talked about as an HOA, wanting to see gates that emergency vehicles can access, like some kind of pass, or I don't know, like their lights flash and it'll open. But at this point, there's nothing set in place. And so I think that's a false statement by Mr. Evans' attorney. But anyway, I agree, like with 29 more homes and so much more traffic, there's a lot of safety concerns coming on and off 287. Coming from Fort Collins is a scary one, trying to turn right. And I do have another thought. My daughter rides a school bus every day home from school, and they go up and down Howe. So if it was that dangerous for us to be driving on, why are we letting our school buses take that route? Just a thought. Yeah.
Thank you. Yes, sir.
My name is Justin Christensen. I am the first man of the ex-president of the HOA of the Paddocks. I'd like to point out too, along with buses going up and down Howe Road and going through Soldier Springs, that it's becoming a road biking destination as well. So it's very commonplace for us to see road bikes coming out of the cement plants along Howe Road and going up to Soldier Springs. I do it as well. I'm also one of the people that cuts through the Knolls, Chaparral when it gets really dangerous. We must have had a fatality over the 4th of July weekend somewhere along 287. They closed down 287. So the traffic piled up. So I cut through the Knolls, made my way home and got around the traffic that was stopped up. I'd just like to point out too, I'd love to have 29 more neighbors. So I'm totally supportive of these parcels coming in. I love it. I like everything about it. My worry is when you really start gauging those turn lanes along 287, Howe Road's, and we'll let that lay where it lies. You know, we'll keep working with Mount Cement and Mitch and working on the future, but I think we do need to look at the future, you know, at some point in time. But those lanes along 287 we've outgrown that. We're bursting at the seams. If you go southbound traffic taking a left, you're seeing, and when traffic piles up, you'll see all the Colorado drivers, Utah drivers, and some Wyoming drivers peeking out behind the semis to dive into that left-hand turn lane. And it's really, really dangerous. Now going northbound and taking a right-hand turn, you have to turn on your signal right at the snow gate and hope and pray that somebody doesn't blow you off the road. So it's even more dangerous taking a right-hand turn going northbound. And my estimation, we have 45 homes or so in our HOA, 29 more coming in. I anticipate if you keep these conditions as they are, we will be attending funerals for some of our neighbors. Somebody's going to get it at some point in time. We've heard accidents. We live about maybe a quarter of a mile as the crow flies from the highway. Last Christmas, we had a head-on collision that we could hear from the house. And we called 911 and said, we heard something that was really loud. We see some hazard lights on and somebody's really in trouble. So I would plead with you guys to really look at that intersection at 287. It would help us out a bunch. I also work with Michael Peck along the improvement district as their treasurer. We're looking at some different options for like chirp gates at those things so that we can let first responders through. That's something that I would employ too, if we could plead with the developer and the improvement district and do some grant writing and enlist the help of the county. That would solve that problem, go a long way. Maybe Western Cement would we offer some services too and some insight and counsel as well. So I'm really warm to those. And I know that Michael Peck and I, you know, a bunch of us had conversation, and we've never really been able to nail down who has how road. You know, is it public? Because we've read some old documents too that say that public access cannot be denied from it. So there's all these conflicting statements that go way back that were released to us via the Freedom of Information Act. So my plea with these people, and Amara and Diana, I appreciate everything that you guys say, but in your questions that you had for the powers that be, they're valid, and we do need some help. I do feel also we live in a place too where we don't have that emergency access, where we've welded our windows shut and framed over our back door. It is serious. And I appreciate all the extra questions and the planning, but if the fire marshals are saying something, you know, I think it's in our good sense to listen to them. If they say, hey, these are big concerns, let's address it. So those are my, I've taken more than my fair share of time, but I appreciate you guys taking the extra look.
We appreciate you guys taking the trouble to share your thoughts with us. Others, and if to some extent, if you want to support what you've just heard, say so. If it's something new, then let's explore it. Right.
Okay, my name is Tracy Ballman. I live in the Paddocks as well. I do want to reiterate the traffic issue, but I also, and I really appreciate Ms. Hanning bringing up the International Fire Code. I work for a fire department, and what I would love to do is, the codes are there for a reason. I don't know if we can dig a little deeper to see if something like that can supersede what we're talking about here, but the codes were made to prevent loss of life. And a lot of those codes were because there was a loss of life. And that's why those codes are in place. And I would really hate to see, I mean, the fact that they're saying that this is a concern and got an attorney and things like that. I think it's almost negligence, to tell you the truth, to see if we can't dig a little deeper to find out if somehow we can apply what they're saying. So that's my 2 cents on that, coming from a fire department standpoint. And then on a totally left field, I don't even know if this is applicable, but from a wildlife standpoint, that's an antelope thoroughfare, and I believe birthing grounds. I saw a calf last week that on wobbly legs that I believe was probably birthed out there, and I'm just wondering if we could have some type of wildlife study put in place before anything's approved, to see if that's applicable to preserve and protect that area. Thank you.
Thank you. Others? Everyone's going twice online. Mr. Ralph, you look like our only public online. You want to be a public?
Well, I have no comment. I don't think I can add anything that Joe and the representatives of the Paddocks didn't already add. I'll just be here in case there's an engineering question, of course, but I think everything's been fairly well addressed.
All right, let's close the public hearing. Is there a motion to close the public hearing portion of our consideration of this application? Second, to close the public hearing. Further discussion of that. Hearing, seeing none. All in favor say aye.
Aye.
Aye. Opposed, same sign. Thank you. Okay, public hearing is closed. Obviously, a lot of concern, both from the board and from the public. I'd like to start with another round through our staff and our attorney. It sounds to me like this boils down to a jurisdictional question. So what say you, gentlemen, to what you've just heard? Specific question about, are you convinced that we have no jurisdiction to address traffic questions regarding this application? That's what I've heard you to say.
Yeah, so Mr. Chair, Commissioners, we can address traffic. We have through what's already been accomplished, right? Through the engineering studies, and then the second look of the engineering study by Mr. Schneider. So to go above and beyond that, I'm not sure we have much authority to do that, or, I mean, it's not in our regulations to go back and continue to redo it after we receive, you know, the anecdotal comments, I guess.
Okay, I guess one of the key pieces was for Mr. Williams suggesting that a revised traffic study had in fact been done at some level. Did I hear that correctly? Let me look for, one of the suggestions that we've heard quite clearly is that things have changed since the first traffic study was done, and it merits additional examination. Your early representation of that was perhaps a little iffy. Want to take a second crack at that or firm up what you said earlier? I would offer that I don't think this is the forum to relitigate the status of Howe Road.
Well, he's looking.
Please.
I've always understood there was a plan to extend the 4-lane construction of 287 all the way to town. Is that a thing that's going to happen? Because that would solve a lot of these problems. Or at least the 287.
So I remember conversations years ago. Once they completed the last section of that 4-lane, my recollection is YDOT said that they're done. But I mean, obviously things change, and you know, to say they're done, I don't know if that's the case. I have not heard anything lately about any additional, construction and widening of the road. The one thing you can do is you can get on their website, and they have their STIP program. I think STIP. I don't know, but they outline the next 5 years of when or what projects they're going to do. I know it's not one of those, so it's going to be at least 5 more years out if they do anything. But I haven't heard.
It'll be a while before all these houses are built too, but it sounds like there's a current problem. So it's a serious issue.
So, yeah, I guess in regards to the access issue, Mr. Williams has represented that in his continued conversations with YDOT on the traffic impact study, that it does not change their opinion about the adequacy of, I guess, the turn lane apparatus off 287 to City Ranch. And we cannot dictate what YDOT standards are for a US highway that is completely under their control.
That sounds reasonable. Again, my question was just to confirm what we thought we heard earlier. Mr. Williams, do you want to add anything to what you said earlier? Do you feel that YDOT has done an updated study essentially and come to the same conclusion? Yes. Okay. It certainly isn't a very pressing issue, as we've heard quite forcefully here this evening. Thoughts from my fellow commissioners? The only other substantive thing we've heard would be to put a note on the plat. I guess I'm personally unsympathetic to that, and that it puts us kind of taking sides in this ongoing dispute. Mr. Ayers, what's your thoughts on?
Yeah, further, I guess the running theme of this evening is I see no requirements in what needs to be noted on the face of the final plat that would even approach putting such a note on the final plat. That is a completely private matter between Neptune and I guess subdivision buyers and Mountain Cement, which does not involve the county.
The only thing I'm hearing that we might be able to do is settle the question of whether or not the emergency personnel really do have access to get through those gates. Can we require that is resolved and that the fire department knows it can get through and they know how to get through and they can do it quickly?
I mean,
again.
From my understanding, they have a skeleton key that gets through pretty much anything, but I don't.
And is that within our jurisdiction? I keep coming up with that. What I'm hearing earlier is that would be nice, we can encourage it, that we cannot require it under available statutes. Is that
correct?
Okay. Mr. Ayers, you have anything to add to that? Yeah, okay. Other suggestions of what this body can usefully do to resolve the residents of the paddocks seemingly legitimate concerns? Perhaps this simply is not the forum for that resolution. Please.
So at full build out, that's when the second access road is part of the plan right now, is that right?
Yeah, it's on the preliminary plat to have Garrison available. So that's what we have approved.
How does the county try to petition YDOT to lower speed limits on any part of 27? Is that anything the county commissioners can leverage to get a speed limit decreased?
Mr. Chair, Commissioners, I mean, they can request whatever they want to request. I mean, whether YDOT will be amenable to that request, I mean, that's, who knows?
State entity with their own thinking. I guess my last question is, I'm a little bit concerned to hear that it's part of the covenants to maintain the Presby systems on some regular basis, and it sounds like that has dropped off the radar. I mean, if you don't maintain these, they're just like a conventional septic tank leach field, right? You're not going to be getting your. Is that something that can be conditioned in the approval to require annual maintenance of the systems to ensure that they're meeting the 30 milligrams per liter?
Well, I mean, Mr. Chair, Commissioners, the Presby system is different than the Advantech system. The Presby system is a system where instead of having kind of a trenched leach field, they still have a trenched leach field, but they have these different chambers they use. They kind of swirl, and they've got some fabrics, and they put them in sand. So it's actually kind of a leach field type system, which honestly, I don't know what exactly the maintenance is on those. I know there's a lot more maintenance on the Advantech systems. But I mean, I guess that's a question that maybe we should look into, because from what I'd heard, that there's not a whole lot of maintenance when it comes to the Presby system, because they are just the chambers that are in the field. Well, Mr. Hinckley, you kind of looked into them a little bit. I don't know if you have anything else to say, but.
My literal understanding of them is that's one of their selling points, is that they're a passive system. But I did, as I copied you on Mr. Gerg's note to our Albany County wastewater engineer, I don't know if she's had a chance to look at that. Ms. Erickson is coming up to speed on these issues. I don't know if you had any opportunity to talk with her about the whole idea of enhanced systems. Of course, has been in the middle of our aquifer discussions, as well as paddocks. Am I correct to think the county is developing expertise in this matter?
Yeah, absolutely.
Because I think that's a hopeful sign.
Yes, yeah.
As far as here, again, it's frustrating to keep coming up against we don't have the jurisdiction to solve these problems. That we're not here to solve all the world's problems. We're here to exercise our judgment within the constraints of statute. Other thoughts? How would we like to resolve the proposition before us?
Part of me wants to table it until we can have all 5 of our commissioners here, but I don't know if that's going to change the outcome. It seems like everything that we're concerned about addressing, we don't have the regulatory backing to do. And having two more people probably isn't gonna change that unless somebody has a brilliant idea.
Yeah, I don't see what's gonna change.
I would, unless we have something that we feel we need to learn, that would be formative of a different decision, which we're certainly hearing nothing from legal or technical staff that suggests that that's the case. It would seem this is ripe for decision.
Well, then I guess I'll begrudgingly make a motion. Because our legal staff already has enough lawsuits that they're dealing with. But I have to add the variance language in for the cul-de-sac.
I don't think that you do.
Okay, that's by reference kind of.
I had that same question. Let's let Mr. Ayers address that, because it did seem like that variance is kind of an orphan in this process.
Yeah, so I don't think that variance is the correct term in this exact situation. The exact language. So specifically under the cul-de-sac street provision in the chapter 6 subdivision improvements of the subdivision resolution, it states that the maximum length of the cul-de-sac shall not exceed 600 feet unless the lots adjoining streets are 1 acre or larger, and special permission is granted by the Planning and Zoning Commission to have the street extend an additional length. So I think with that specific language just to cul-de-sacs, that takes it out of like the general chapter 1, section 11 variance standards. So it would just be to, I suppose, the language would be and to grant permission to extend cul-de-sacs beyond 600 feet.
That would be part of the motion that
Yeah.
we're invited to make at this point. So if you were crafting a motion,
I just gotta write down what you said before. I move to recommend the Board of County Commissioners approve paddocks at Fort Sanders second filing, second edition subdivision application SP-13-22. Adopting and incorporating the staff analysis, findings of fact, and conclusions of law as which are stated in the staff report, and including permission to grant and grant permission to extend the cul-de-sac beyond 600 feet.
You add and a subdivision permit.
And subdivision.
staff, is that a well-crafted motion? Okay, there are no objections. Is there a second?
I'll second.
Further discussion?
The county commissioners don't have any more authority than we do. Is that right? On this?
That's correct. Yeah, we're basically standing in for them in a recommended capacity. Okay, Ms. Hanning, what say you?
Aye.
Mr. McCarty?
Aye.
Strictly votes aye. The motion passes. As I believe is clear from the discussion, there's considerable concern going forward for what we've heard expressed, and certainly encourage folks from the paddocks to work with planning staff if there is a useful role for this organization to play in resolving these issues. Let us find it. Mr. Gertz is a well-educated and clever fellow who may be able to add something to the process. If we don't have statutory authority to act as a commission, then that's simply the fact that perhaps there's some encouragement to be applied to various agencies through the planning commission. Again, I'm just speculating, is that it's fair for me to invite folks to come meet with you, Mr. Gertz? Sure. On these concerns, because they're certainly legitimate, and none of us want to see any accidents.
And maybe communicate with White Oak and try to put some pressure on them. I think that was instrumental in getting the 4-lane part built. I don't know what else you can do.
All right, we are through with that. Did Mr. Edwards, you were waving your hand down, did you have something?
I was just gonna ask, since this is a recommendation to the county commissioners, if we know the date, then it will go to the county commissioners for discussion and.
Mr. Gertz, you know, August 1st. August 1st, 9:30 a.m. here. Thank you. Okay, and did you all hear that, August 1st, 9:30 a.m. in this room, if you want to pursue this further. Thank you for your attendance and contribution. All right, let us move on. We have several other items on the agenda. The next one would be proposed amendments to the Albany County zoning resolution prospective sign ordinance.
Yes.
Who would like to speak to us about that issue?
Sorry, yeah,
Matt's gonna take this.
Okay.
Yeah,
Why are we here? Where did it come from? What are we trying to do?
okay.
It's behind mine.
Oh, it's by yours.
Mr. Evans, may I ask you, I think.
Oh, yeah, you guys, the mics are picking up all of the room conversations. Mr. Evans? John, can you guys take it outside? Unless you want to share it with the world, but open mics are perilous things these days. Good suggestion, Mr. Evans, thank you.
Thank you, Mr. Chair. Okay, so in 2016 or thereabout, there was a United States Supreme Court case, Reed versus the town of Gilbert, Arizona. I may have those names switched. And the holding was that under the First Amendment, any regulations of signs cannot be content-based, or else it'll be in violation of the First Amendment. There has been a little, I suppose, nuanced holding since then by the United States Supreme Court, but that basic premise is still true, that if you have to read the contents of a sign to figure out its permissibility under any sort of zoning regulation, that is impermissible under the First Amendment of the United States Constitution. So our regulations do just that currently. And we need to update them so that there can actually be some sort of standards for signs. Because currently we essentially don't have any because they couldn't be enforced, or else it would just right off the bat be a First Amendment violation. So this was a proposal that I worked on with an extern from the law school, and have since worked on with Mr. Gertz and Mr. Wilms. The central premise is that there are two categories: signs requiring permits and signs that do not require permits or are allowed as of right. And under the signs allowed as of right, smaller permanent signs in agricultural and zoning agriculture and commercial industrial zoning districts, and then temporary signs for a duration of which it was
90 days.
Yeah, for 90. I was sorry. Oh yeah, and we might recommend that be extended to a higher number of days, just to make sure everything is okay with political campaign signs, because that's a big one that you can't really regulate. And then of course anything that's, I suppose, required by law or a government sign. And then signs requiring permit, we did it by, whether it's a permanent sign And depending on the zoning district, you get, X number of a certain size per zoning district. And then lastly, we thought it prudent to put in sort of an on-premise property sign. Now, of course, this sign could say anything that it wants, but I was thinking, kind of like the entryway to like ranches, those sorts of signs, or like apartment complexes, anything like that. Those have a little different size standards. But other than that, the maintenance, renewal of sign permits is remained essentially the same. So are there any questions?
Yeah. Go right ahead.
Okay, so the sign height
Yeah.
is allowed to be different if it's like on the side of the building. Right, that it's, when I look at sign height definition, but excluding any portion of a sign structure that is above the sign face and is part of a building or structure that has a primary purpose other than supporting the sign. So like if I were Tumbleweed gas station.
Yeah.
And I put a digital sign on the side of my building. And really, when I wanted a sign, I wanted something much bigger and taller that you could see from the highway. But I couldn't get that at the time. But if I put a second story on my building and put my sign up higher, that'd be okay.
No,
No.
because, so it's excluding the portion of the sign structure. So essentially the portion of the building that's above the sign. Like if you already have a building that height.
Top of the sign.
Okay.
Yeah,
Okay.
so anything from there, because technically like the side of the building in that scenario is the sign structure. But we're saying that we're just counting the portion of the structure that's from the top of the sign to the ground.
Okay.
And anything above that is not part of the height calculation.
Okay, cool. There's a lot of requirements in here about not having like twirly, flashy lights, but would it be a good idea to have like a, I can't remember what the term is for measuring brightness of light, something. Lumens. Is there any benefit to having a cap on how bright your light could be, even if it's not flashing or moving?
Yeah, certainly.
Okay, I don't know what that number should be, but just again, thinking about how upset people were about the sign at Tumbleweed and how it was going to be shining into their homes. That's my only sign experience that I'm going to as an example. So I don't know what that number should be, but it seems like having a cap on part of this. And then, so this exterior, it's called an external light fixture. Is that what does that mean? Is that like a light that sticks out from a wall to shine down on your sign as opposed to being a light embedded in the sign?
So that was
What was that question?
there's a portion that I did not change an external light fixture illuminating the sign. I think it's just, it's anything
General requirements.
that isn't like self-illuminating. Yeah, I mean, basically anything that isn't like a digital sign that, is illuminating from like the bulbs of the sign. That's just saying that has to be pointed down.
So you can have some on the ground, I guess, point up. That would eliminate anything from the ground pointing up at the sign, right?
Well, yeah, and I guess it's
Pointing it down.
been that way for forever.
So right now, you currently re-permit these every 3 years? Or is that a new component?
No, we do not. That was removed.
Because I got confused because it struck out from one section and I just thought maybe it was moved up as a new thing. And so I didn't know if it was like moving around an existing requirement or if this is a new thing. And I wondered how you felt about re-permitting these every 3 years.
We did do that at one point, but I remember we did have it removed quite a few years ago.
Not according to the current subdivision resolution, or sorry, zoning resolution.
Well, it happened, it may not have, maybe it didn't get taken out over the years. So, well, I don't know how that got back in there, so.
So why was it taken out?
Just, I think it was just pretty time intensive, to go out there and to redo those every 3 years.
And the person with the sign pays a fee, right, to be reviewed or to get a new permit?
They did, yeah. That's how we were doing it.
So is
Just,
it important to get them inspected on some periodic basis, and should it be a longer term than 3 years, like 5 years or 7 years?
You know, I'd have to look back. I mean, we did it, but then obviously we moved it, so there was a reason. I can't remember if it was just staff time or I'd have to have, you know, look back and see why we did change that. I guess I can't answer that. Super.
Are there a lot of signs out right away right now? Like, or is that I know that's a problem for some gas signs, but is it still a problem you're seeing?
In the right of way?
In the right of way?
No.
In public right of way?
No, we don't have too many signs in the public right of way.
Why
Those are
not?
Private lands.
Yeah, why not? I mean, it has regulations for like any sort of right of way for I-80 or 287.
What you're looking at, I was quite confused by the color coding here. I was unclear what was,
Yeah.
what was out and what the old sign, the old one said. So I guess just as a general editorial comment, this is quite confusing to me as to what was replaced, what was not replaced. Like this inspection stuff is what it appears to be in.
Yeah, based on the version of the current version of the zoning resolution, which, you know, is on the website, it has that renewal requirement in there. So I don't know.
I've got 3 colors of the
Yeah, okay, so the 3 colors,
red, green, and blue.
red and blue are the same. I think it just means that I honestly don't know exactly what it means. I think maybe 2 different authors because it differentiates color by author. The green means that it was moved internally. So yeah, that is confusing. Apologies for that. We would definitely, going back, we would just change all the color to red.
Just a red line strikeout.
Right.
Okay, it was just an interruption while you were getting your thoughts together. Go ahead.
You get rid of off-premise signs. Is that because they're just, so in, I guess tied up in that is, what is a billboard? Is a billboard an off-premise, or is it a different category?
So, okay, so under the on-premise, off-premise distinction, which is wrought with conflict-based determinations, but the typical determination is whether it's advertising something that's on the premises of you know, the sign that it's on, or off the premises. But then it gets weird. I know that my office internally, we had a hard time because there recently was a case out of Austin, Texas that went to the Supreme Court, and they said in certain instances, you can make an on-premise, off-premise distinction, but it still can't be content-based. And it was proving pretty unworkable for us to make any distinction, because if you look at a sign, like I'm thinking of the, you know, more like political, I think it's a pro-life sign in between here and Cheyenne on I-80. What is that? Is that on-premise or off-premise? And you're also then, just by its definition yourself, you're describing content of what constitutes, you know, whether it's advertising like a good, something like, you know, goods, services, activities that are on premise or off premise. And the other trap that you have to watch out for when making that distinction is that if you are giving, I guess like commercial speech more permission than you would be giving, because you can regulate commercial speech differently than other types of speech, but you can't be more permissive with commercial speech than other types of speech. So ultimately, this is our advisement on how to structure it, is just avoid that on-premise, off-premise, and just go strictly by size and zoning district.
So how would it work if there is a gun auction at the county fair and they place those, political sign size things around town saying, gun auction at the county fair this weekend? Is that's okay under?
That's a temporary sign, so then you really just have the, and it's also, yeah, and if it's in the city.
Oh, yeah, good point.
Yeah.
All right. Okay, those were my questions. At first, I was concerned about the teeny tiny signs, but then I realized those are your by right signs. And if you want to have a bigger sign, you just got to come in and pay for a permit and get permission for it. But if I'm a farmer and I want to advertise that I'm using seeds from Monsanto or DeKalb or something, I could put those all over, a certain number of them of a certain size on my ranch property to let everybody know what I'm using.
Yeah, because we also wanted to be considerate of that, like, no trespassing signs, like maybe safety signs, which would fall under to, if it's below a certain size, you have a decent number of those by right, or in the case it's required by law.
Right. Thanks. That's all.
Mr. Carney.
I actually didn't before, but so are we gonna take out the retaining part?
I don't know, Mr. Church.
So I did find this, which is weird because like I'm looking, this was taken out in 2018. I have no clue how it got back in here. I'm looking at regulations from 2019. It does not exist. The reasoning was staff time and the fact that it doesn't change how the process that we remove them. If somebody tells us there's a sign that's, kind of beat up or whatever, we can do the same thing. We just don't have to go out and spend a bunch of staff time to do this every 3 years. I would recommend not doing it. I mean, honestly, it's like, I feel like it's a little dangerous being out on the roads because you have to stop. We would stop and take a picture of the things on the highway, interstate, wherever, So, I mean, just to keep my staff off of those busy roads too, would be, the county is nice as well. Now, I would love to have that not be in there, so.
Okay, I have no idea how it got back in. Maybe that was
Yeah,
my
like,
fault.
Maybe
at some
the
point.
extern started with an older 7.
Well, no, because it's in. I printed this
It's in the
online.
current ones, yeah, I don't know how they
This has the APOZ regs and it's in here.
So kind of follow it through to see where it shows back up again, so.
So I think for the purpose of that, I would just leave it in there, but just strike it.
Yeah.
So there's no,
Strike it again.
yeah.
Okay, I'm okay with that.
All right. Billboards. I was quite confused about this whole thing, to be fair about it. I haven't studied the old ordinance and I wasn't clear what's new and what's old, but just as I try to populate it from experience. All right, we've got a slug of billboards at I-80 on agricultural land coming down a telephone cable. When I read this, those cannot exceed 20 square feet. And once I'm looking at it, for 200.
Correct.
We're banning all those billboards. If they take them down.
No, we're
they're
just
not
saying
gonna
that
be
to be 20
permitted.
square feet. I mean, they will exist. Those ones are grandfathered.
Those are
They can't-
non-conforming.
Yeah, they're non-conforming. They won't go
If
away.
you added a new one, it would have to be.
Okay, but I'm understanding that right.
So this
No more
would-
billboards.
Functionally look at that, yeah.
So you still have to come and get a permit for a new
Anybody wants to do a new?
If they
one,
take
yeah.
it down and want to put something up, they're
No
limited, they would be limited to that.
So those guys all have permits? They're just there.
I'm pretty sure that most of them were been there since previous to our zoning regulations or sign regulations.
Okay.
I mean, the signs that we typically permit in the county, the ones that I've seen in my tenure here in the last 15 years are on premise, the ones for businesses and those types of things. Very few billboard type signs have been permitted.
So do we have an inventory of the billboards? I mean, how do we know what's?
We do.
We do.
We do, yeah.
Okay.
I don't know, and 10 years ago, an intern of ours went out and GPSed all of the billboards. Funny little anecdote story. I mean, a lot of people don't like the signs. When we implemented the requirement for the fee and the inspection every 3 years, one of the guys that had signs got all mad and he cut a bunch of them down. I was like, oh, well, that takes care of that. It was pretty funny.
I mean, there are a lot of studies citing.
And the fee was like super cheap too. It was like $50.
Yeah.
It's not much.
Citing the dangers of large signs of distracted driving.
Billboards are actually dangerous.
They can cause distracted driving.
Because it seems like small signs, you'd have to, we take more of your attention to read than a big one.
If you can't read it though, then you kind
Yeah.
of forget about it.
No one's gonna pay to put their sign up, you know.
So that's our rationale for not having billboards is the safety.
Safety and the view aesthetics.
All right, well, so let's, I mean, I'm having a problem with the whole thing. Maybe I'm kind of libertarian on the signs and shit. I've put up hundreds of political signs over my career. So totally unacceptable to regulate political differently than others. I mean, that time, place, and manner, that's standard First Amendment stuff.
Yeah.
So no surprise there. It's all the rest of it that I have trouble with. So the authority under which we perceive this at all is safety. That's Karnak's question. Is that right?
Health, safety, health, welfare,
Morals.
morals.
I feel like it's gonna be very unpopular.
It seems
I
like.
mean, like, so gas stations have their prices posted and I mean, they're at this exit and all that.
I mean, right now, we don't really allow giant billboards. I mean, what is the standard? They have to be small. I mean, they get bigger. We allow bigger sign on I-80, but not like those giant signs.
300 square feet is the
Are the
biggest.
big ones still allowed on I-80?
They're all grandfathered.
No,
Oh,
the grad,
okay.
yeah, the ones from, well, in the existing regulations. Yeah, the big ones, they're all, yeah, non-conforming.
And
So-
they can maintain those and change them or whatever. I mean, like, they want to change the name of the gas station or something, they can still keep the billboard or they wouldn't lose it at that.
Right, if they change the name, I mean, that's just the message on the sign. The
Oh, I
sign,
see.
if it's there, I
The
mean, you
sign
put whatever
exists.
message.
Okay,
you
so we're
change
not
it all.
gonna have more billboards, but we can keep the ones we have, and if they all get knocked over in a tornado, then they're gone.
Yeah, and these
Yep.
regulations have to be such that you can read the regulations just fine, but if you try to read a sign, you can't. You're illiterate at that point.
Well, one thing I'll point out about these regulations, everything's negotiable. We just came up with these things.
Yeah.
If you guys want giant billboards, it's like, I'm not like a sign person,
Because
person that hates signs or anything. I mean, I don't really care for them, but it's like, you know.
Yeah,
Just
currently
saying.
the biggest you can get in the I-80 corridor is 300 square feet, and according to this Lamar advertising, the average billboard is 672 square feet.
So the grandfather, just to pursue the grandfather argument a second, if they fall into disrepair, these regulations require them, or they have to have it populated, for example. Billboards often will be blank until they get any customer to come in. Is that, do they forego their grandfathering? What is it that's grandfather? The structure?
The structure, yeah.
No matter what, whether
Yeah.
anything's on it or not.
We have standards, like, there's a standard in there that says if you don't have something on there, a message, it should be like painted white or something like that. So you can keep it like that until you get another, actual sign with a message on there.
So the other things that come to mind, there are still political signs out from last election. 4x8 is the standard. I mean, it's plywood masonite, whatever it is. Okay, 9 square feet, I think, is the number we read it here. But that ain't me. That doesn't get it. 32 is the right number. Just we're supposed to chop things down, and we can go back and fine tune these. But just a reaction to this is that, and I'm very skeptical that on my own property I can't put up signs all over the place and tell my neighbors what I think and what I think they should think.
You can, you're just limited in what you do, and you have to get a permit.
In the size, but I'm limited in the size and the duration. And we're permitting 600-foot tall wind towers with the name of the manufacturer in probably 15-foot high letters all over the place. I guess that's not a sign. I mean, as far as the visual effect of big letters up in the sky.
Right. I don't know if we allow that.
Yeah, I don't know if we,
I mean, we allow safety signs and those types of.
Well, I mean, every wind turbine I've seen has a big sign on the side that says who built it.
yeah, that is, but I think ours say,
And so we're not gonna allow those. That'd be interesting.
Oh, and winter.
Yeah.
yeah, so I remember,
Looks like a sign if your idea of a sign is a big thing that sticks up in the sky and has some wings on.
I'm just taking care of those.
Yeah.
Just, I'm joking.
I'm just a lot.
there shall be no signage, logo, advertising, or promoting lettering of any type allowed on the WECS tower, cells, or blades, with the exception of reasonable manufacturing safety warnings and emergency contact signs.
So, yeah.
Good answer.
So, no dice.
So so the ones we're used to seeing in Laramie County is full. We already
Yeah.
have those.
I did notice that this weekend.
Interesting. All right. So, I mean, I don't know, my reaction is this is not ready for prime time. It sounds like when I hear Mr. Gertz say, I'd love to get rid of that. Well, let's go back to it. So that's just my general reaction is the sizes I find too small. The number of signs, I mean, it's hard for me to believe that that's somehow more distracting. If I'm thinking on agricultural properties, the most common sign is a no trespassing sign. Some people just like to put on every fence post. I find it offensive, but I don't think it's regulatable. So I guess I'd like to go through this more carefully in terms of the words, what say my fellow commissioners.
Well, it seems making sure it's consistent with whatever rules there are about political signage. And aren't there rules that the county clerk has about how, when you're supposed to remove signs after the election? I don't know if they have.
That's probably
signs.
election law. That has nothing to do with land use law. I don't think. There probably is. I don't know.
We don't want to be in conflict with that though, right?
I mean, there's also,
I mean, that's something to look into.
I believe there's restrictions on how close you can place signs to a polling station.
Those have actually been struck down.
Was that, I thought that was the,
recently.
I thought that was
Oh, really?
the campaigning.
Well,
Did it also
electioneering.
include sign or electioneering?
Well, okay. So
I don't remember if it
were terms that were used. I understood it to mean the signs as well, but perhaps
I was-
election judges we were instructed to back off on any of that kind of stuff.
Yeah, because now I guess you can like pamphlet.
Right up
Pretty
to the
much.
door.
Yeah.
And fair enough. The point is you cannot restrict me by the content of what I'm saying or signing or anything else. I mean, I think the city has some issues with that in terms of political signs. But you've purged that from the
Right. I mean,
correctly.
yeah, and I like what Matt's done here. Just like there's nothing to do with content at all in here. It's all just
It's a temporary or
Yeah.
permanent, and then if it's permanent, allowed as of right, or depends on the zoning district.
What if it hurts the morals of our residents?
So as long, I mean, I just did this with the library board. In order to, so it has to be truly obscene speech. Pornography is not obscene speech. So.
What is obscene?
We can have a sign.
Yeah, let's go over this. Well, okay, sorry, it depends on, okay, so it depends on the level of, okay, some pornography is, but not all pornography. We're not gonna get into it.
This conversation.
Yeah, how did we get here?
What's the thinking on different districts? I understand that doesn't get to political versus commercial speech. What's the thinking on having different rules for residential and agricultural, for example?
Well, I guess so that you can't plaster the side of your house with, I don't know, signs telling your neighbors to do horrible things, but or you can, it just has to be limited. It can't be the entire side of your house, it just has to be a little smaller.
I mean, I think the big separation is those types of properties compared to like commercial industrial. It's like commercial industrial is like, yeah, this is where business is happening. You want signs, that's fine. You know, residential ag, they're kind of a unique.
Well, and ag
kind of
to
their own little deal, and I don't know.
Ag to a certain extent is gonna have like a little more kind of commercial purposes a lot sometimes.
Larger, pieces of property.
Yeah, especially like if it's a working ranch, then certainly. So, and that is honestly, that is like the most straightforward permissible way to do this is to differentiate according to zoning district.
Yeah,
That's
no,
explicitly recognized.
I'm not suggesting that it's illegal or unconstitutional. I'm just wondering what the rationale is for having different rules for residential versus agricultural.
Right, and I think like with the number of signs, we thought of, you know, ag, we want to have, they can put as many of those or a bunch of those.
A lot of no
trespassing
trespassing
signs,
signs.
whatever.
Because that's their prerogative.
We sat down in a room and came up with numbers.
Yeah.
Okay, we gotta start somewhere.
So this is like, yeah, by no means like gospel.
All right, to be continued. I mean, those are my reactions to it. So I think is what we're up to this evening. Go ahead, Mr. Craig.
So the giant banner, is it on Warren showing over there by?
In
the city.
That's the city's.
In the city.
That's the city, okay.
But that
So
would
that's probably not
be
allowed.
Now,
too big. It would not be allowed in county. It would be too big.
Yeah. But it would be grandfathered.
No, well,
It's in the city.
if they were to move it into the county.
Just and hypothetically, if it were in county.
If it existed, yeah.
Not
and it would be just an immediate lawsuit.
Oh, I know what you're talking about now. I was
What
like,
with
what are
the,
you
what
guys
with
talking
the
about?
little syringe and the gerbil?
Yes, yes.
I want that thing they're done with it.
I was like, what are you guys even talking about? One towing. Oh.
I think it's I-80.
I-80,
Yeah.
Yeah.
All right, other thoughts on this, on the sign ordinance?
I think what you said, I think we don't want to overregulate stuff. But neither do we want to clutter our, you know, the aesthetic argument has some basis, but the safety argument, if there really is a safety problem, that's our strongest reason for doing this. Because aesthetics are subjective.
But aesthetics have been recognized by the Wyoming Supreme Court as part of that.
Have they? Okay.
Yeah, view sheds, that's what Teton does for a lot of like, you know, capping height of buildings. I could find, it's in Teton County versus Crow is where they discuss that part of the general welfare is like, you know, aesthetics,
Okay.
like natural view sheds, sorts of.
Yeah, I agree with what we want. Just the question whether we think that's appropriate. I'm sympathetic to Mr. Hanning's lights. You must not have been here when they had the Foster arrows. Remember those? Oh, they tore it all down. Now Foster's there at the corner of Curtis and I-80. It had this big sign that had these big two arrows that would go up, but then they'd come like this.
Oh, really?
Oh, you can see them from Cheyenne, and they were active. They would do this arrow thing.
Oh, really?
Over and over again. It was a pretty amazing piece of work. It was on the satellite maps. So I guess I would argue that that's the point. Like the lights on top of towers. The light pollution, I think is real.
I would agree.
And it's something
Yeah.
that's
That's a
that's
good one.
worthy of regulation. All right, more to be said on that. So let's feed comments into these guys as we go forward and we'll continue to tinker with this language. But certainly unanimity on getting rid of regulation of political speech. All right, let's see, do you want to take a short break before we proceed into our next topic? Yes. Yeah. Okay, we're recessed for 5 minutes. All right, thank you very much, everybody, for your patience. We are back in session, and we are now looking at the second of our current planning projects, that being amendments regarding ingress, egress, which have become quite a timely topic thanks to the first hour of this meeting. Mr. Gersh, what do we do here?
Yeah, so Mr. Chairman, Joe actually put this together. This basically will require that there's two separate points of access to a public street for any subdivision that's over 20 lots. Or if it's connecting to another subdivision that has 10 lots and then they're doing 10 lots, that would trip that threshold and they would have to have a second ingress egress as part of their subdivision application. So basically what we're doing is just trying to add that second access in for fire safety, not just to get the fire apparatus or whatever in here, but the people out as well.
So let's expose that to our earlier discussion. If that were in place today, this discussion about paddocks would look different. Correct.
Yes.
Okay. Usefully so, I'm sure that's correct.
Mhm. Yeah, so the gates may not, they may be good ingress egress for fire suppression, but the people in there could not use those for ingress and egress, so they would have to have a second ingress egress. Now, that being said, I don't know if I want to get into the weeds or whatever, but like if you have City Ranch Road that goes all the way up, that's a public road. If you have two accesses off of City Ranch Road, you're still coming out on City Ranch Road. So,
Yeah. Where do you start?
but it meets the.
So is there a way to address that? Like what are the right turns, arterial, I mean, like a more,
You could say two separate, you can say there needs to be two points of access with each one going to a separate public road.
But it's what it says, at least two separate points of access to a public street.
Public streets.
But yeah, it would have to be
To a separate public street, I guess.
That was
Two separate public streets.
Well, yeah, I would love public, I mean, you're getting to a state highway, you might have to play with your language to distinguish two different ways to get to City Ranch Road. We need just two different ways to get to 287.
Yeah.
In case of paddocks.
which that would be. So, technically, if they had 2 points from the subdivision to City Ranch Road, that would be good under this proposal. But if you wanted it to be the alternative, then you would have to say it's two separate public roads, so they would need another one. Either,
Okay.
yeah,
So
So one could go to City Ranch Road and one could go to 287 directly. They both end up on 287, but at least have two routes to get there.
yeah, because but I mean, that also might not make sense in certain situations. Think about like maybe Tammy Powell's,
Two separate access.
where the accesses were
Yeah.
right onto 130.
Right.
But
So then that would be in
That's-
violation
that would
of that.
Right.
that would be
But
different.
there is no other, or there's no other split at each end.
for subdivision.
And they were gonna cul-de-sac. So there was like 10 on each, and each one had a cul-de-sac off of.
Oh.
So they would be under the 20 threshold.
But I was saying like if they were to be over the 20 threshold, I was just using that as like an example. Where if you have one that's like along a highway, then
Yeah, if you do any
That would-
loops, I guess that would prohibit that, so.
Ask for variance.
but you would still have the 2 points of ingress and egress. It just wouldn't be on the two separate public roads.
I don't know, and I think when we think about these things, we need to think about it for whatever can happen, Really thinking it as a global type thing and not, because we're trying to apply everything to the paddocks right now, but we shouldn't do that, I mean.
No, but we had these examples in front of us with paddocks and Tammy's thing that we need to make sure we cover those. And
Right.
give you a
Sure.
reality check on the thing, which I think is useful here. What is that? Does that mean a public street? And two separate public streets, just because this one and this one have different names? That counts as two different streets, even if they were go this way, it would only be one.
Oh, yeah, you're talking
yeah.
like Reynolds and Spring Creek.
Yeah,
Like
geometric.
if you put it, I mean, because that's like at 17th, it becomes Spring Creek, but I mean, it's the same road as, or no, sorry, no, that's not Reynolds. What is that before? Curtis.
Goes to
Curtis.
Curtis and then goes to
So
Reynolds.
Russell and Spring
Or-
Creek is what you're-
Yeah, Russell, sorry.
Oh, yeah, it's Spring Creek.
Yeah.
What is the city equivalent? I mean, this is what Mr. What's his name's doing with that Laramie subdivision on Strand, is he's fighting these 2 points of access.
That got struck down.
He's not.
But yeah, they withdrew their application, but
Right, so that was about 2 points of access.
it was about 2 points of access, yeah. I mean, they would both end up on Grand, so I mean, that was gonna meet their criteria. So I don't know what there's, I don't know what the regulations are.
It's all more geometrical. What's your recommendation? I mean, this is a new act, this is a new section, just to be clear, we're doing it completely new.
And it's a subdivision design standard.
Okay. Where it lives.
So there was, this also came out of discussions with Albany County Fire District #1. This has been run past them. They wanted to insert language that said, if a proposal connects to any road already that is not part, the number of residential, and it said, and determination will be made at compliance of, the compliance will be determined at the point of the final plat. I didn't think that was necessary, because it kind of throws off the entire point of our subdivision. Perhaps we could, our subdivision resolution as it's structured, perhaps we could insert some language, but it's basically chapter 6 applies to both preliminary and final plat at all times. So if there's any, and although the subdivision resolution, it does not explicitly state, but if there's a deviation from a preliminary plat and then to a final plat, it's a different proposal. So my advice would be that has to be denied at the final plat stage if it deviates from the preliminary plat.
Right, this is section 9 of chapter 6.
Yeah, I just wanted to state on the record, I guess, like the concerns from Albany County Fire District, but I disagree with their proposed language.
So what, Mr. Kirk, are you recommending we adopt this as it stands? Concur with it, it's certainly very, very close to what we're interested in.
Right, I mean, we feel comfortable with it. This is what we've worked through, and like Matt said, we discussed it with Fire District #1. So yeah, we would be comfortable adopting what we have here.
So, but it wouldn't have solved tonight's problem, though, right? You could have just done 2 things out to Sea Ranch Road.
It would have, but then that would have also required a revised preliminary plat.
Yeah, they would have had to do a lot with that.
It wouldn't solve the residents' problem, which is getting off City Ranch Road.
Not if he,
Well,
no. But it's also, I mean, with that traffic impact study,
like
Why not?
Matt's saying, they would have had to turn in a new preliminary plat which would have kicked in all of our new regulations.
Right, I don't know. Yeah, that's why they met their 36-month requirement to expire.
because there was no time requirement.
Oh, that's right, that's new.
Yeah.
Is there a way to tie this to, like Arterial Street, Collector Street, like whatever the next, depending upon where your subdivision is, if you're nowhere near 287, then, but you're close to a Collector Street, like would you be able to say you gotta have 2 points of ingress out to a Collector Street? If you're near an arterial, you have to have 2 egresses to the arterial. I mean, is there a way to make it
We
like
have to define those
locationally
things.
fluid so
Yeah.
that you don't have someone doing it?
So that would only be applicable if it's a county road, because those are what we designated as like the arterial collector. It wouldn't work for highways. And if it was like a publicly dedicated but privately maintained road, then it wouldn't apply there because there would be, sort of classification because we only index county roads, like true county roads,
Right.
under that designation.
Yeah, the only designations that I actually know of are on the major street plan. Those designate where there's collectors, arterials, and that's only a little bit around the city. Once you get a ways out, then there might
Road
be
and
some.
Bridge has the standards for
Do they?
like widths of.
But have they
whether-
designated those? That's the thing, is like, I don't know if they've been designated. That's the hard part.
Do you think we have county roads? And
We have county roads, yeah.
we have privately maintained public roads like we talked about.
Right.
Correct, all of that time.
That's it. And we have state highways.
So, or we also have, district maintained public roads as well.
And I believe the state has some type of standard to determine, if they're functioning as these types of roads, because they do, one of the part, within the major street plan, there's also another plan, functional classification plan, where they actually do studies to determine if they're functioning like a collector or they're functioning. So the functional classification plan shows you how they're actually functioning, That doesn't mean we can't define them another way, but
I was just looking
it would
at
be
definitions in the.
more of a lift to do that.
The plating and subdivision regulations sort of have definitions for collector street, local street, service road, freeway.
Well, maybe that could be applied then, I guess I don't.
So I just didn't know if there.
But we'd have to go through and define them. They're not.
Well, I think it's not in the definition section, but it's in the standards. Oh, no, it is definition, section.
But I mean, we would have
definitions.
to go and like designate roads
Oh,
as.
you mean in the county, say
Yeah.
what is considered an arterial street?
But if you said county roads instead of public streets, that would bump you up quite a ways.
But there would also be subdivisions where they
They're going straight up
like,
the-
there's no adjacent
There is no county.
county road in Tamacao, or no, sorry, not Tamacao, like Windmill Acres, like down south of Laramie, that's because Carryland Lane, that's private.
I mean, Tammy,
Right.
Is Vista, is that public, or is that county?
but they also would
So state
mean,
highways.
they wouldn't mean that.
Like, it's-
like.
Yeah, but even
I know, I'm just,
I mean, Tammy is though.
At least
I'm just thinking of like road
Even
configuration.
then you have subdivisions that don't have access to county road, but they have perfectly good access.
But they have access to state.
Okay, so what is it, when you say a public street, that would mean a street to which the public has access. with reference to-
It's
Dedicated.
a public easement basically on that street, yeah.
So even if it was maintained by a local district or somebody else, that would be that.
Yeah, this is tricky, because again, if we're trying to like.
We don't want to eliminate like every subdivision ever,
Yeah.
but we would like to.
There's a lot of, like Timber Canyon.
Yeah. Right.
Sunset Acres, we have lots of ways to get to Rocky Canyon Road, but once you get there, you can only go to town.
Right, yeah.
You can't go out to the Hall Road anymore, you can't cross that. And they closed for street in the winter.
Right, but we can't chase this out where everybody has
Right.
instant access to
Yeah,
it.
it is,
This is a large step in the right direction.
but it doesn't solve the paddocks problem.
But it does not solve the paddocks. But the paddocks, as I think you were alluding to, it's got a lot of problems in its whole relation to Power Road is, sure it is.
How will, upon full build out, how will they put in the second access road?
Garrison.
Garrison is supposed to be, when they did their original preliminary plat, which is different than what we're looking at back in 2007 or whatever it was. it had Garrison, which is on the major street plan too, so it connects with Howell Road all the way down to City Ranch Road. So that access was there, and that was gonna give access to, everybody in that subdivision could go to Garrison and up and Garrison and down. Well, that's when the Hall Road agreement came about, but then there was all sorts of negotiations and Garrison would still exist, but they basically eliminated a lot of those lots. I mean, the homeowners now that we're in here talking, they don't have access to Howe anymore because the gates are blocking them. But if they open Garrison, at some point they could come down and hit Garrison and go back up and come around if they wanted to, but.
Even like the preliminary plat in 2019, now it's supposed to connect Garrison to Artillery Heights, which then leaves Sebastian and City Ranch.
Where?
Garrison.
I would also just recommend changing public streets to
This
public
was-
roads in that first sentence.
Should be there.
Yeah, it's roads.
Oh, so it'd have.
Art, do you have any?
You can't link it to approval to the county fire district. As approved by the county fire district. You can't just loan them that approval, right? Because it doesn't exist somewhere in a statute.
So what we could do, because actually like this is kind of an issue that I've flagged, is like we send it out to all these agencies, but we have no regulatory backing for even sending it to them in the first place. So like we need to put that in, that it's gonna go to these agencies, and then what do you do with that? And I think it's conditions may be based upon the recommendations and review of the agencies to a certain extent, but I mean, it does get tricky because it still should be tied to our standards, not the standards of like an outside agency that we don't have any connection to them legally. Or do we have the authority to impose their standards? We would have to essentially write their standards into our subdivision regulation, which is what this is getting at.
Right.
Because really, like for the state fire marshal, they actually review for compliance with international fire code is very limited.
Commercial buildings, any public buildings with a lot of people that might be going into them. I think they may do some like connection stuff for residential, but like they don't get into subdivisions, they don't get into any of that stuff. It's all about structure.
It's only certain types of buildings.
All right, let's get a little further afield, but it goes to our earlier discussion. Can't we, through our subdivision authority, allow ourselves to regulate based on their recommendations? Now, that isn't giving them veto power, it isn't adopting all of their standards. It's simply saying, if we find something in their comments that we think are important to meet our obligation to the health, safety, of welfare of the county, we can impose those. Is that too slippery?
We essentially
It's
do that
very
with,
slippery, or it has the potential to be very slippery.
we essentially do that with DEQ though, right? Because they're giving us a recommendation.
But they have an objective set of criteria
True.
that they have developed based upon the statutes in the subdivision, county subdivision statutes. Like chapter 23 comes from 185306 C.
So I mean, and maybe if we wanted to do something like that, we'd have to,
Like,
okay, so wildlife, if Game and Fish says this, or this, then we can do this.
which is, because you kind of have to have like objective or.
But we did that with a tower permit out north, and there was a wetland adjacent to it, and the Game and Fish said we would like to see wildlife-friendly fences, and we made that a condition of the application.
The applicant was agreeable to it.
Well, okay, maybe that was.
And that's like, because, you can always ask, will you do this?
Okay.
But there's a difference between that and true condition.
And tower permits are kind of, they're like our WEX permits, they're kind of a conditional use permit too, so.
Yeah,
I mean,
so-
There's ways to add conditions on those.
So really, the fire districts around the state need to collaborate together on like a statute that would allow them to create safety rules for subdivisions.
I mean, we have quite, when we're talking about the fire district, we have a lot of information in there for fire suppression and those types of things.
But it's mostly related to fire suppression
Yeah.
systems.
I mean, we do have some standards, if they have like a cistern or whatever, we have some standards for where roads can go or whatever. We could probably give them some authority through that to, to review and make sure that they have adequate access. I mean, maybe that's something that we could slip in there and give them that additional authority. If they would want it, I think we would want to talk to them and say, hey, do you want to be able to, give us some guidelines? The problem is they haven't really adopted any standards either. So it's like, if we're just giving them authority to like willy-nilly say, yeah, we just feel like we should do this, but we haven't adopted it, so.
Because
I don't know.
Yeah, and I mean, there's nothing in 18536 about a review coming from the fire district. So that's something that we have gone above and beyond in, but under our current design standards, that's really it's not for like IFC fire apparatus permits, which.
So we kind of serve as an ombudsman on the list of 15, and then we provide an opportunity for those agencies to communicate with the applicant if they choose to. And that's not nothing, but that's a long way from conditions of approval.
Correct. Because oftentimes, people are like when when Game and Fish says that they want to see wildlife friendly fencing, they're all right with that. And also now there's the fencing statutes that we have to enforce.
Well, the conservation district will recommend seeding mixes and so forth, which is all just cooperative, that's not required. All right, well, what do we to dispose of this? I mean, I guess I would not be averse to passing this forward for review as a part of this larger discussion that's going to take place in months, years to come.
I'll review by all those other agencies.
Well, I'm thinking of, our procedure would be if we like what we see here, then we would put it out for our 30-day review before we can certify it as a recommended change in the subdivision regulations to the board. That's the.
I would like to figure out how to word it so that it would address the problems that I realize we're not going to fix all subdivisions, but that is a specific thing. It really was a problem. This would not fix it.
And do we think that that's within reach?
It could.
So.
But it depends on where they put that second one access.
They would probably put it on City Ranch Road.
Yeah, they probably would.
It would be in compliance if they did.
Their biggest problem is 287.
Yeah.
So I'm not sure.
Dumping everybody on City Ranch Road if they're trying to escape the fire is not going to happen. Or if the fire trucks are trying to get in that way.
The mountain subdivision standards, they word access a little bit different. Provide 2 or more access roads for separate multiple ingress, egress due to fire and related safety considerations. Loop drives with 1 entrance point do not satisfy this need.
Oh, that's like internal loop.
Yeah, that's an amount something.
Yeah. But I mean, I don't know if that kind of language, it gives you any more specificity to avoid. I mean, is City Ranch Road essentially a loop? Because it's not going anywhere else. It's not, and it's an in and out, it's not going anyplace else. I mean, I don't know. I'm just throwing ideas with it.
I mean, it's not really a loop, that's just a road, but like if within the paddocks it looped to City Ranch Road, that's what we're worried about. Or those, if we applied the mountain subdivision standards, they wouldn't be able to do that. But it's not really, I don't know, that's interesting. It's not really.
Is it a dead end or a cul-de-sac? I mean,
City Ranch Road goes to the paddocks and stops. That's all, that's all that exists right now.
Public street is not satisfied.
Well, we're not looking at City Ranch Road. That's not what we're
That's not-
looking at.
No, but just thinking about the situation there, if we put in language about how the public street can't be a dead end street,
I feel like
it might address the problem.
the looping.
Oh, like you're saying if it,
Yeah, I mean, if you could get over to I-80.
so maybe.
Then it would work.
Okay, so maybe it would be to a public road
Itself has 2 points.
that itself has 2 points of access to a, to
But
public
it
roads.
gets you to a public road that has 2 points, right?
Yeah.
I
No,
mean-
because it only has 1 point of access to a public road.
No, I'm saying like, once you get on City Ranch Road, you hit the highway and you can go wherever you want. You have all sorts of points of access.
Which only have 1 point to get to the highway.
Yeah, there's only 1 point of access from City
To the
Ranch
highway,
to
yeah.
another public road. So it would be then adding a second layer where the public road itself has to have 2 points of ingress and egress to a public road.
Yeah,
I mean, we have a limit that it has to hit first, which we don't hit very often, so I
That's
don't
true.
know that, like doing something like that is uncalled for.
Maybe we bump it up higher instead of 20 to 30.
Yeah, that's what I see.
Yeah, IFC is.
And that way, like, honestly, we don't see big subdivisions. The Paddocks is huge. This is like the one in a,
And it
one
would
of its
still,
kind
and it would
in the
still hit
county,
that.
you know? We've got, yeah, I'm not sure if we hit 30 on, there's the Vista Buttes and the Vista Grande, they're both bigger subdivisions. I'm not even sure if they'll hit 30, you know? So now,
This is certainly something though that we can put, so schedule public hearing on it now. All of what we're talking about is well within the realm of this proposal, so it would not be a substantive change if things are tweaked.
That's kind of where I'm thinking. It's not solving all of these problems, but as I play with these geometries, I just seems like they unravel. I mean,
Mara, do you have any recollection of like city standards for this? Maybe,
They have a standard for when you need to build roads, but I don't remember off the top of my head, but there is one.
and that's information we can easily figure out.
So what's the
Second
what's the-
access.
what's the second access?
they can get an agreement with the terminal. Okay, what do we want to do? Move this thing forward, understand it's not perfect, or we could try to improve it. It's not a pressing issue, but it's one that comes up.
Maybe somebody in the public will have a suggestion that works better than what we thought.
That's certainly.
You know, set those folks that were here tonight to think about it.
Certainly.
Don't have to- I think that would be fine.
Right, maybe we have.
Sure.
So do you want to move to send this to public hearing? To what's the right term here?
so it would be move to direct staff to publish the subdivision access amendments and set public hearing for, it would have to be,
At least 30 days out.
what?
At least 30 days out.
So at least 30 days out. So with that publication, it would need to be, well, actually,
You want to put it on September?
we have to put it on the September meeting.
Yeah,
Unless a special meeting is.
yeah, that'll give us plenty of time.
So we could also work on it in August, though, if we want to.
Yeah.
Now, what the commission did, which I thought was a really nice way to handle the late submission of data, was as part of the notice, I don't know, maybe that idea came from one of you, they closed written comment 5 days before the public hearing.
Yeah, I think that was a discussion we all had. I don't know if we brought it up, but I think we talked about it.
I think we
passed
have
it on.
time, I think that's it, like, we're
the 6th even, just so that make sure everything is included in the package.
Yeah, that's what I would do.
Yeah.
That's what,
Just make that part of the notice.
And that would be.
Yeah,
part
to
of-
make sure
That would
we
also
get
be
it in
part of
there.
the motion. So to close and to require all written public comment be received by
September 6th.
September 6th.
Okay, so I move to direct staff to publish Albany County Planning and Subdivision Resolution Amendments to Chapter 6 Subdivision Design Standards for public comment to close by September 6th.
And set a public hearing for September 13th.
Set a public hearing for our regular meetings. Written public comments by September 6th. An in-person public hearing. at regular meeting.
Or 8, 13.
put that down word for word.
All right, are we clear on the motion?
David is.
David is, all right, David's the one who has to be here, Joe. All right,
I'll have him do the minutes, it's fine.
formal motion, let's do a vote. Ms. Hannah.
Aye.
Mr. Carney.
Aye.
Votes aye, opposed, same sign, hearing none, motion carries, thank you. Okay, so that moves us to the cap. Obviously, we're not going to get clear through this. I guess you were going to do a cap update. I assume you're just going to announce
Yeah.
where we are. So yeah, please do that. Then we'll move
Yeah,
on
let me
to
announce where we
discussion.
are. It's been approved.
Yay!
So, yeah, it was approved by us. What day was it? The
5th,
July 5th. And then that night, it was approved by the city council. We have a joint cap, which is to me amazing. So, good job, you guys. That's all I have for that.
It was approved unanimously by city council on a vote of 2-1 by county commissioners. Unexpected, and it was endorsed by EAC unanimously. I don't remember that vote, but
Yeah, yeah, it was there.
so up to that. Whatever we were always calling the gang of 19, it was unanimous, and then at the official level, it was 9, 10, 11 to 1. So very good.
Was it unanimous in city planning?
City, yep, both city planning and city council.
Yeah, okay.
Yeah.
City council.
Council was.
I
Okay,
can't remember
guess
the
I
city
can't-
planning.
City planning was not. There
Was
was
it not?
two against.
Cause I can't separate the other plan and I don't remember what the.
Okay, I'll take
Yeah.
that back. I don't know.
City planner there was 2 against, but
Maybe that's what I'm thinking, I don't know.
and I'm not sure about the cap.
Okay, so we have a joint cap as we did from 2002 to 2008. That's what the county split off, and now we've put everything back together, reconcile their differences. Okay, now then we move into the interesting process of regulation. So just to understand what you provided us, Mr. Hirsch, as I understood it, you gave us just a raw compilation of the Stantec recommendations. That was the red line strikeout.
So yeah, I provided two things. The red line strikeout of the Stantec compilations. I also provided some language for that the amendment to the boundary line.
Right.
And then I know Mr. Hinckley's worked on that too, so.
So on that first one, that came to us without any staff recommendation or anything. That was just strictly, here's what Stantec said.
Yes,
Is that
yes.
correct? Okay.
Yep.
So you
Absolutely.
haven't tinkered with that at this point.
No.
And then the one that we, as per, I think what we discussed at our previous meetings, was that the one that we've drilled into as our initial piece, and I think is the most controversial of the new material is the boundary. Certainly, there are some controversial things from the February 2023 regulations that are controversial, but we aren't changing those.
Yeah.
As opposed to this one, which we are. So what's your pleasure? Do you want to make a quick pass through the Stantec just to see if there's some places that we want to probe further? I assume, Mr. Gertz, you were going to then do likewise, come to us with a recommendation. Yeah, one of the big standouts there is that the Stantec had included all the septic tank inspections and specific nitrate values in zoning regulation, and the direction we've been talking about is to move those over into delegation agreement. So I'm assuming that we're going to do some major adjustments of what Stantec has given us.
Yes, especially the septic portion, yeah. I've passed it on to Lisa in my office. And so I think she has actually corresponded a little bit with Matt on that as well. What's that? And me, yes. So, yeah, we need to work through some of that and kind of figure things out. But yeah, we want to really get our heads together and figure out what's going to work for the county and what's not, and just something that's clear and understandable so we can enforce. So yeah.
Okay, so what if we left the first piece, the Stantec recommendations, as just a working document for ourselves? You'll come back to us at a subsequent meeting with your recommendations.
Yes.
What we want to do with those, and as will we. Is that sound like the way to proceed? What's your understanding of what city planning is doing? We're not going to have this glorious same identical document, but I'm concerned that we coordinate closely with those guys.
Right. So I did speak with Derek T, the planning manager. From my understanding, they're going to tackle the western boundary first. They're just going to, I think they just want to get that approved. And then he didn't have a lot of direction after that. So it was the boundary, and then they were going to go look at the text amendments afterwards.
And are they waiting for something from us, or they're just diving straight in?
Yeah, I don't know if they're waiting for us to do anything. I think they're still they were waiting to get the plan kind of taken care of, and then they're going to regroup and then kind of figure that out. So and we'll have conversations. I'll have conversations with those folks over there and coordinate a little bit to kind of see what each other's doing. So.
Okay. And that's consistent. I had a conversation with the chair of city planning, Chris Moody, and that was pretty much what he expressed their interest in the SSIs, which is the thing that the city has had most involvement with. They've seen like 57 of them. We've seen 2, 3.
Yeah.
And of course, as far as the boundary, 90% of the boundary is in the county. But we need to remind ourselves, and they need to remind themselves, we are regulating activity in the APOZ for the benefit of all the residents of Albany County, 90% of whom live in the city of Laramie. So I'm happy to hear that we're kind of headed in the same direction on that. Okay, then if we want to leave all the rest of that, we'll get to it, but if we're all agreed and if city planning is on the same boat, then let's move on into the boundary issues. We know from public comments that that's something that's a concern. Now, there are several relevant documents. Did you incorporate the Stantec boundary in the red line strikeout of Stantec, the first item? Does it include all their talk about how to do boundary changes? Because they had a section specifically about boundary changes.
Yeah, whatever was in there that I didn't see a whole lot in that section.
And I don't know if they put it in the red line or not. Maybe, I sent it to you guys earlier. Did you get that piece?
Oh, I got what you sent me, yeah.
Okay, why don't you bring that up
Okay.
as a starting place? And again, you guys dive in here, as how to organize this, but here's what Stantec recommended for doing boundary changes in the body of the text. And I don't know that they had a specific thing in their recommended regulations. I think maybe not.
Aquifer protection overlays not established, and that's number 5. And little p is APOC boundary amendments.
And that's in the red line from Santa.
Yeah. Page 3.
Okay, so that presumably is coming out of the, we want to base our work on the cap, which is the approved document.
Is this the right document? I might not be able to see it.
Yeah, no, let me compare. Yeah, maybe this won't work to my eyeballs. That's mine, I think. But I also had I just extracted from the cap the relevant pages. I love that size. But yeah, let's, the other one was just an extraction of 4 pages from the cap.
Oh, do you want that one?
Yeah.
The extraction part?
Yes, please.
All right.
So basically, we have 3, one of which came from Mr. Birch, one of which comes from the cap, and then the piece that I've been playing with in concert with Mr. Birch and Mr. Birch. But here's what the cap says, which is now, I think we're calling it Stantec. It's the adopted cap of Laramie and Albany County. Yeah, that we'll do notches.
Why is it?
So basically what the cap now says is we have the boundary which follows the survey lines. And if you want to change that, if anybody wants to change it, they have to go through this process. They're recommending that they be required to go through this process of a site-specific investigation. And they're sticking with the recommendation that it be a survey line, second point there. And that all be substantiated with a specific report. So scroll down. And these are all kind of relevant points to what Mr. Gersh has provided us. The cap suggests that can be done by anybody who's interested, a developer, property owner, interested party. So there's some disagreement on that. And I don't know what they meant by a waiver of the CAPA restrictions. What were they thinking there, Mr. Gertz? Do we have any interest in having a waiver as opposed to simply moving the boundary?
I mean, that would be like the exemption language, exempt them from the regulations.
Yeah, which I think we all agree we don't care for that approach.
It would be easier, yeah. I think it'd be
We'll
easier
just move the boundary. Okay, so holler, you guys, obviously we've had this discussion before, but these guys were offering some kind of a squishy, the boundary's still here, but we're gonna do exemptions to it. So we're kind of moving it, but we kind of aren't. And then I think significantly, they provided this figure 4.2, which is the next piece. Yeah, this one. So I don't know if you remember this from the cap, those purple zones. There are 3 of them. The long one there out on Rogers Canyon Road. The one out kind of in the Jacoby Golf Course area. is the middle one there that you're seeing. And then there's I thought there was
To the south. there.
oh yes, clear down south of Simpson Springs. So, and I've changed my tune on this as I looked at their appendix of how they did the western boundary more carefully and looked at the individual wells. And it's clear that Stantec rose to the challenge of doing a much more thoughtful and systematic and importantly, well-documented job of where they felt the criteria of 75 feet of undisturbed tank shale lay. These are the three areas where our consultant Stantec felt that they would have been happy to have more data to bring to bear on that. So what I took from this diagram and having looked at that appendix a little bit more is that we may take a much easier path to allowing folks to come to us with petitions to move the western boundary. And if they, with the exception of these special areas, if they stay within what Stantec recommended as meeting the 75-foot criteria, we make that a relatively easy process and not go through this more elaborate process that Stantec outlined above and the fairness I had been suggesting. We have conceptually identified, I think, following the city's lead in 2008, that moving to the nearest surveyed boundary serves two purposes. One is to clarify the boundary for purposes of the homeowner, of the developers, the land owners, as well as the regulators. So there's always value in clarity of having the lines in the right place. I know the planning staff were quite strongly about that. But as it was expressed in the 2008 CAP update of the city, it also provided a margin of error. I've softened on the need for the margin for error in the areas where Stantec felt that they were pretty confident. I say that bears on how we go forward. And then the next page bears on this same point where they're suggesting that, I think it's in that next priority, when I blow that second part up, the one that talks about going ahead, doing some drilling. One of them says we got to go figure out where the boundary is.
Test hole.
This one right here. Yeah, there you are, number next to priority number 3. So this discussion took place over the course of the CAP, and those of us who were participating pretty actively in the public comment portions of that. Originally, Stantec suggested that we require the owners of those lands in those purple areas to conduct these investigations, which could get quite expensive. And our suggestion, I can't remember what it came from, the gang of 19 or our technical committee or whatever, anyway, out of that give and take and mix was that we thought that was just too much. And that should be something that falls to the county. If the opportunity presents itself, somebody can round up some grant money or so forth. The county are the ones who should take on the job of refining the western boundary generically. Now, if an individual wants to do something right there, then they'll have to pick up that map themselves. All right, so there's what we're getting from the CAP. Now, let's go, I guess since we've distributed it, let's bring up Mr. Gertsch's recommendation. We can talk through a couple of specific issues there. So if we can bring up the piece that was in the packet, I think would be the fairest to our viewing public. And then we can include in the minutes. I've submitted an alternative that I've been working on that I just didn't get right enough for putting in the packet. And anybody's welcome to dive in here. I kind of thought this through a bit, so I'll yak along here till you stop. All right. Yeah, you've broken it out as a specific. Okay, so the piece I had added to this was, this refers to the map. Yeah, there we are, that second paragraph, was to make the point that the map simply illustrates where the lines are. The actual boundaries are the written descriptions that you'll see in the books. So I've offered alternative language here that would make it clear that the maps, and that's true of all of our zoning maps, they aren't the last word. They illustrate where the boundary is. The actual boundaries are those survey lines that say 47 feet from the southwest corner, such and such. So I'm looking at Mr. Gersh, is that acceptable?
Oh, absolutely, yeah, I think that should be in there.
Just a
Yeah,
clarification.
I had a question that
Yeah,
might be
please.
relevant here. So if somebody does their site-specific investigation and the boundary moves, does it still have to stay on a survey line?
Yes, they will have to provide a survey line.
They'll survey it.
The suggestion here
they'll
is,
have to
Okay,
provide the
okay.
survey.
and so that, the way this would be written under the next refinement to what Church has provided us here would be the APOZ boundary lines are all surveyed lines. That's how we're gonna do boundaries.
Not necessarily property lines.
But survey lines, right? And so if you want a different boundary, then it's on you to bring a survey line forward. And there was a discussion that Mr. Platt led of GIS lines, and survey lines, and I think the resolution of it is that and 75-foot line in quotes could be surveyed. I understand that, right?
Oh, okay.
Yes.
With some effort.
Well, yeah, I
remember that
mean,
conversation.
what would have to happen is, so anything on the GIS, it's part of a coordinate system, so you can get like GPS points. You know, you can figure those out. I'm not sure exactly the process. I asked Jake Schneider what it was, and he explained it to me. I still don't know what he said. So, but it's basically he has to find some kind of a point on the ground, and there has to be a coordinate system on the ground, and here, so you connect it. So when I said you can't survey it, I was wrong last time. So I'll just admit that. But yeah, we've had quite a few discussions, and so yeah, we could do that.
And I appreciate those discussions.
Yeah.
And was surprised that the GIS at all, you can describe a line as vectors and curves, which I think is the right way to do it. They did it as segments and points. According to Mr. Platt, there's like 180 points. Which is odd, because then when you blow it up, you see the segments. But anyway, we do have a line from Stantec that could turn into a survey line. All right, so that was my first refinement here. Then the next piece was who gets to request these changes. And I don't see it immediately, but Mr. Courage, I believe that when you got to that point, you were trying, your suggestion was that we confine this process. Sorry, let me back up two things. One, the county's generic moving of the line, just like us changing additional dwelling units. Those would have been considered global changes to the zoning resolution. And those are governed by the Administrative Procedures Act.
Well, so long as our amendments which were adopted February 21st, 2023 apply or are upheld.
And the suggestion that I'm promoting is we keep those. So we have two levels of change. If the county is changing it as it is right now, the county can do that. And don't have to post a sign at every property and do all the registered mail and all those notice things. I would characterize it rather like if we were to change the criteria for rural residential. We are actually changing the rules on everybody who's zoned, but we do not require of ourselves individual notification. That's a generic change. Maybe that's not quite.
Yeah, well, because the individual notifications are something that if not for the zoning resolution, would not be required. That's just something that we've imposed upon ourselves as additional notice.
Okay. And so the suggestion moving forward from here is that if we are going to do our APOZ boundary changes on a parcel by parcel basis, then those are akin to our process for asking for a zoning district amendment.
Correct.
And then we would then require of ourselves the same process there with respect to notices and notifications. So I think both the Gertsch and the Hinckley language makes that distinction. We're all happy with it. We're happy with that. And I would include Mr. Ayers in this to the extent he's been part of this discussion. Okay, so we're not changing that. That language stays the same as the February 2023s. Now, the Gertsch version uses site-specific modifications. I call it parcel by parcel, whatever you guys think the right terms are there. And those would then follow the existing notification requirements, which are you have to tell the neighbors, you have to put the signs, and so forth. Now, somewhere in here, it's who can make the application. I believe the Gertsch version says it has to be the owner. And my thoughts and Stantec's were anybody can do it. So talk to us about why you thought it was important to limit this site-specific changing of the boundary to the owner.
Yeah, I mean, I just think I don't know if maybe Matt can ask us, like, it doesn't seem like it would be legal to go on someone else's property and change a line that only affects that property, to go in and, I mean, can you do that? I mean, I don't know.
Hold that quick for what?
So, okay, so like,
I want to change the APOZ boundary on your property.
yeah, can someone come and do that?
Only with your permission. If they don't let us on, then we can't survey anything.
It would follow our current zoning, change process, because the property owner has to sign the application. If they don't, we will not go forward with it. So, I mean, it's just consistent with what we're doing now. I don't know, I just think it's odd that someone else can come in and change somebody else's,
Every
well, right,
Change
all
the
our
boundary.
applications.
Well, you could change the boundary as it lies over there, but you couldn't get a survey on their property without their consent.
Just as a practical matter.
Yeah.
Yeah, because the only county entity that has any sort of easement is the assessor, and that's the only for
Well,
assessment.
let's set that aside. I'm picturing the old ordinance, which was this crazy process for adding and subtracting. But the seed of value in that was that if someone concluded that Stantec was wrong and that a piece should have been included that wasn't, I think we should have a procedure for them coming forward, making that case. So I would want the opportunity to petition have your land included if I thought it had not been included in error. Any sympathy for that? Now, again, I could get my surveyors on there without your permission.
You would just have to present data from nearby wells and like 3-point problem of your different.
Yeah, right, just did a big resistivity survey and I just go to well on my property just across the line and holy smokes, I thought it was gonna be 500 feet, it was only 7.
Right.
That there ought to be a way, and maybe there's just generically a way to come forward to ask for an amendment on ADAR, which there is, right?
Yeah, because you can always just petition for a rule change.
Well, and if that's the case on that property, or there are other properties, if you're getting like 2 or 3 or 4 properties, now it's kicking into that other process where you do a comp plan amendment and then you do a regulation. I don't know, I don't like the idea of it, it doesn't give me warm fuzzies to like go, allow other people to change boundaries. It's like saying, well, I'm gonna come to your property and change your zoning because I just want to, Now you can't do it.
The proper way would be to, petition for a rule change under, I think it's under 18.5, 202 or 202B, and then also it's in the Administrative Procedure Act.
And if we wrote this method for doing a site-specific change, that would preclude somebody coming forward with new evidence to see that this would find.
Sorry, that last part.
Well, okay, you've been wrestling with this in multiple lawsuits. I'm looking for a home for the mistakes. If the 75-foot line, or well, I shouldn't call it that, they call it protective Tatanka line that's brought to us by our consultant, is found to be wrong. How do we make it right? Without running afoul of this crazy business we got into, if you have to change the rules, about changing the rules before you can change the rules.
Yeah. So I guess you would define the scope of like the global amendment versus the specific amendment. I guess like if it involves just a singular parcel, or maybe, one or two, it would be site specific. Whereas like global involves more than.
So if my scenario involved more than one property, then I would fall under category A, where I'm just proceeding under the Administrative Procedures Act, not under these detailed rules. Okay. Which would most likely cover this situation.
I mean, wouldn't it be difficult to get data on that property? I mean, say it's like a bigger properties. Yeah, you got some information on this side and this side. I mean, do you have enough to do it? I mean.
Well, I hate to anticipate the technology in the future. I mean, here the county participated in Brad Carr flying around his helicopter, spying down people's backyards.
Black helicopter project.
Right. I would, personally, it would take a lot to convince me this is on this.
Like, what would happen if, like I'm thinking about out Roger Canyon Road where there's 40-acre parcels that are zoned rural residential, and the owner could subdivide. Right now, their houses are way up high on the ridge. But if it got developed and lower down and people put in wells, and they found through their well that there was not 75 feet of protective Tatanka, and they choose not to report that so they don't have to move the line themselves. But it's publicly available data. You see that a well has been drilled, you go look at the well log, and you see that there's not 75 feet here, and that the line's in the wrong place, but the property owner doesn't take the initiative to bring it into reality of what they now know about their land. That's the only time I can think where an outside entity might be like, well, hey, we know this now and the line should be moved, but the property owner isn't gonna take it.
Well, that outside entity should be the county.
Okay, but it would be the county doing it on less than a global basis. But maybe more than a parcel basis. That would be the exit we want to preserve. I'm just looking for a home for that scenario.
So you want an intermediate, you want site specific map, what intermediate?
Well, I mean, is it asking too much that the county can move the boundary?
Yeah, because you would just do it through APA and you put forward that evidence as your basis.
Right.
And then that accomplishes the same thing without.
Okay.
muddying it too much.
Which is just say the county can change the boundary under the APA. Any individual has to come through this process.
Right.
Okay, I'd be happy with that, if that's not too objectionable to folks. Oh, the county doesn't have to play by the same rules as everybody else.
I mean, that objection, it's there currently. So,
Okay, all right. Well, that would satisfy my concern. Okay, and so the next iteration of this, let's follow the Gertz model of the landowner is the site specific, parcel by parcel. And then it's treated like a zoning district amendment change as far as notices. And then we just refer to that whole piece that has a real fair and square aspect to it. Now, what you'll see in my suggestion was that I think the Gertz suggestion had a way to not have it become a big deal and have to go through P&Z and so forth. And there was an attempt, I think Mr. Ayers commented on this, you need to put some objective criteria to that. I was looking for something. We'll know it when we see it. I am sympathetic to that's a little bit less. The Gertz ordinance says you have to have 3 wells. So what I'm suggesting is that
I'm not a geologist, I just threw it out there.
no, it's okay. But it's a way to, you wanted to pin it down. All right, so the suggestion that you'll see from me is, I say, I think what we welcome by the anti-regulation crowd would be that, except for those purple areas, we will assume that Stantec got around. So all you need to support your request to move the line, those cases, is a survey line that stands outside the protected line. That doesn't need to come through us. That's something that you guys can say, yes, it meets that criteria. And then what, it goes directly to the board, how would that work?
Yeah, I mean, I think everybody has wanted the board to approve that, so.
I have a consent agenda, so
I don't think that it can't not come through this commission.
Because we're adjusting the line.
well, but it comes through us without a
so
big report by time.
Maybe my simplified version is not that word.
All right, so we could modify yours to just say that there isn't a big SSI, there isn't a study.
Oh, sure.
It only has to meet that criteria. That's, again, that's.
Sorry, that's for areas outside or inside the purple?
Outside the purple.
Outside the purple.
If you're in the purple, then it looks more like an SSI, then you've got to bring your own data forward and talk us into it. And there, the language I've suggested is loose, and it just says, convince us. We'll get a peer review if we got a problem. Go ahead.
Outside purple, we're saying Stantec got it right, but somebody can change it. I'm not following.
Okay, so, well, all right, so the problem that I thought I heard a lot of sympathy for and was huge in the comments was person owns 40 acres, the Stantec line flips the corner. Whole thing came in.
Oh, right.
Those are the folks that I'm trying to give them an easy out.
Okay.
And that easy out would be if the Stantec line was well supported, which it is, we'll cram from
Outside the purple.
everything outside the purple areas, then all that person, the 40 acres has to do is come in, have a surveyor give us a line, peels off your corner.
And they get the rest of their property to be outside.
That's the
Okay, understood.
So that should be, I don't know what a survey costs. That would be the idea.
It's moving from parcel lot line
Right.
over to the Stantec line.
Right.
So when they get that line surveyed, if it's out of purple.
And they're done. Okay.
That's all.
Okay. I mean, I think that will take care of 90% of our objectors.
Then I guess for the areas outside of the purple, couldn't you just cut that in the first place if you're already going to give them that? and
We don't
just
have
adopt that?
we don't have a survey. Yes, we could, but we don't have a survey. We don't want to go to the expense of surveying.
Well, I thought, okay, I wish Michael was here.
It's surveyable is where the plat
don't have
merges.
survey.
Oh, okay.
That's not a trivial undertaking, I don't think.
Okay.
I just kind of want to take that on. I mean, do you have any sense of what that's doing? These are all licensed professional surveyors, they aren't.
I'm sure the surveys will love it, but we don't have money.
They're racking up that it's just produce the document. This is what that looks like. It surveys, and here's my stamp, and that's, somebody's gonna pay for that.
Right. Yeah.
So that's the only difference. And in most cases, it doesn't matter. I mean, the line's out there, it's ag land, nobody's doing with anything with it anyway. So the point is to only go to that trouble and expense where somebody cares. Trivial?
I'll think about it.
Okay. Yeah, I'm trying to honor the request that it be on surveyed lines, which we currently do not have. And inviting the property owner to provide it. All right, well, think about that. If there are no, I mean, we're not making a decision here, but we're providing direction for the next iteration of this. Does that sound workable? And then many of those would come in quite simply, like the Gonzalez case. They just chop that corner off. And if they wanted to survey it, it's going to cost them more than if they just said, okay, how about that? Right. Just did a single straight line to cut the curve. That's the cheapest, and easiest. They'd be spotting the APOC half an acre or something. That's on the geometry.
So then to the attachment of this, do we need to have like the GIS data or like the estimate line?
We do, but I've understood.
Well, yeah, but like to actually put it in with like the regs, like as an attachment or something to the map.
Okay, yeah.
So then people would actually.
We have the GIS line and, we have that. We can make a map with that included. That's not a problem.
I mean, how would they extract it?
Or they,
Like how would
the
they know
map?
like what the GIS coordinates are for each point?
Point. I mean, if we just make a static map,
No, but all those,
Yeah.
all 108 of those points have discrete coordinates. This is what Mr. Platt's.
Right, but then how people would need to be given access to that. So like we
Yes.
would need like a physical map or a map depiction, and then we would also just need the like raw, the map and like data.
Yeah, yes, I think that's correct.
Okay.
And now you're at the fringes of my GIS understanding, but
Yeah,
that
we're
fringe
well
says-
past mine. So don't
says
worry.
that's possible. And that was the upshot of the discussion. Those points have a discrete location in space.
Yeah, that was what
Which a surveyor could produce the line that.
Mr. Platt's representations to David and I was after speaking with some friends or a friend who was a licensed surveyor is that in Colorado, but is that yes, you can go out and take that and like survey a real line on the ground.
We'll have to track that down, but then we'll also have to add to our regs. Not just the map, but the list, the 108 points.
how do you adopt a digital file?
To adopt digital.
Yeah, it's part of the regulations. Just
Yeah.
refer to
Yeah,
it.
you print it.
It could be put on paper. It's
Yeah, I mean,
108 of them.
because it's like
Then it's not digital anymore.
the
They have no
official-
coordinates once it's paper.
He's saying list the coordinates.
Right,
Yeah.
those coordinates, you can
Yeah.
have them put them out to 30 decimal places, it'll get you.
Like a meets and bounds description.
Oh, I have no clue.
I have no idea how to do that.
I don't know, Michael.
Okay.
I don't know.
We'll explore that, I guess.
Well, and we can't make this isn't the Michael Platt exercise, he can guide that, but no, the planning office is gonna have to be satisfied that they have.
Yeah, but he said it almost sounded like he did, or he had that in a form where it was not the math part, it was not the map depiction, it was like the coordinate set,
Okay,
coordinate data set.
so I suggesting that Mr. Gertz sit down with one of our
Yeah.
registered surveyors and say, does this work for you?
Sure, yeah, I mean. Do we have one of those?
That are, well, I assume there's a small cost to sit down with the surveyor, we're making work for them, so.
Okay, yeah, well, I mean.
Okay, is this a fatal flaw or is this something that's worth pursuing? I think you're right. that it
I don't know enough to
needs be
say
nailed
if it's a fatal flaw or if it's doable or not, honestly, so.
down. All right, let's, because if that doesn't work, then you're right. Then it's-
No, because well, and I, yes, like this isn't, Mr. Platt just completely steering it, but he has put in some substantial investigation into this
Right.
matter, so that's why it would be nice to hear his first,
Absolutely.
his representation,
Right.
and not David or I,
Well, I would like to hear
who may
it.
very easily mess it up.
We are instructing our applicant to find a registered professional surveyor to do this. That is what it would take to make me happy.
Right,
is
but
that
to do that first, they have to make sure that that estimate line can actually be surveyed in a meaningful manner.
But I need to hear it from that registered surveyor. Yes, I can do what you're asking me to do, given this information.
Yeah, well, but we would want to know that before we actually put it in regs, that that's how something
Yes.
to do. Okay.
Yes, this is research in anticipation of putting our regs together.
We will look into this.
Okay. Because, this idea of making it very easy for folks to carve off their non-APOZ 38 acres only works if it's correct that the line is unique and describable legally binding way.
Or a real, like a determinative way.
Yeah. Okay, so if that's sounds worthy of pursuing to my colleagues, then let's see what comes of that. And I know a lot of GIS pros, but I don't know surveyors, and that's the key that I think Mr. Gertz has been waving the flag for all along. I see that stamped there with the registered Wyoming professional surveyor, right? Right. Okay. So you'll find this language between what I've submitted, what Mr. Gertz has submitted, and I think those could be reconciled pretty easily. Then within the purple areas, it reads much like Stantec's recommendations. And it's like an SSI. It doesn't say 3 wells, it's just gonna say, you're going to have to come forward with your evidence that you meet the criteria of 75 feet of undisturbed. And if we, the county, feel the need to get a peer review of that, do so, and we've got language in the existing regulation that allows us to do that at your expense. Now, Mr. Ayers is referring to figure 4.2 of the cap, cause you any heartburn. Because we could identify those by parcel ID or
It has to
something.
be pulled in. When it
Yeah.
did, I think it should.
Yeah.
It's a specific enough map that you can pull it in.
Okay, so it would be an appendix or an attachment or something.
So, I mean, how we have it now is that the zoning districts are, the boundaries of the zoning districts and their associated development shall be determined, they're based as depicted on the official Albany County zoning maps. So, which shall be maintained and made publicly available to the planning department, so. Yeah, I guess you would, and that was a change that we made as part of our zoning district amendment process, so. Yeah, that we've adopted this map, same text, and then it lives with planning.
Okay.
And it could be like, it would be like, pretty much like part of the attachment of the rule change. of the set of amendments, so.
I mean, we have the map book, we could probably just throw it in there and name it something
I
else.
thought we got rid of the map book.
Never was like
That's what.
taken away, it's not online or anything, but.
Okay, well, thinking
So-
about how to put that in, or if it needs some more precise description. Purple areas are a little fuzzy, but there they are.
Yeah, we'll figure it out.
Okay, so with that idea, those ideas going forward, you've got a couple of documents to work with. The last thing on my list picks up on a comment that I'll attribute to Commissioner Corning. And we've talked about noticing and haven't ever quite dropped the hammer on that. Do we want to, because it's required, not as an amendment, send some notice to those who are affected by this boundary change? And if so, do we need a motion to make that happen, or where are we on that? But we all kind of, for general agreement that we'd like to invite them to come meet with the planning director or some such thing, but I'd like to bring that home.
That would, so you're thinking of inviting that prior to?
Yeah.
Okay.
Prior to amending, or the.
Yeah, I mean, we're soliciting public comment, informal way. We're not requiring ourselves to do that because there will be the official 45-day, 30 and 45, all that. This was a separate thing that we were going to do. That we concluded there were maybe 50 properties that are involved. This wasn't everybody in the POZ. This was those who weren't in the old one that are in the new one.
So yeah, motion to.
So we're directing staff to, what is the it? We're gonna tell them what's going on and invite them to come talk to you. So we're left to their last discussion.
Yeah, just invite them to, basically tell them what's going on, yeah. You're going to be impacted by potential change to the western boundary of the Casper.
They're gonna be impacted. It is going to be changed on your property.
Okay.
Up to you to decide whether that's an impact or not.
Yeah, and you wanna come yell at me, this is my address, I don't know. No, we'd be happy to, to discuss any concerns or questions that you have with this change. To get a better idea of what kind of impacts this may have.
Something like that.
So like a postcard.
Yeah, it doesn't mean it's my face.
Here's my cell phone.
Here's my home phone address.
That was from Matt's on there.
All right, do we need a formal motion to direct staff, or are you?
Yeah, no, it should be a formal motion.
Yeah, where we're gonna spend funds.
If that's appropriate. Maybe have such a
Do we have
motion.
to say all that again? For the formal motion?
Well, I mean, we can give him discretion to pick his words and so forth. but-
Direct staff
So,
to notice those.
I move that we direct staff to notify people who are impacted by the western boundary of the APOZ.
As proposed.
As proposed.
Is that enough direction?
Absolutely.
A motion second for the discussion. Very done. Ms. Sandy, how do you vote?
Aye.
Ms. Corning?
Aye.
Include votes aye, it's unanimous. Okay, we've got an assignment.
Sounds good.
And if you want some feedback on the wording, well, gather that up for you, please. I guess you can't convene a meeting of us unless you feel like that's necessary. For timing, I guess, there's no reason that shouldn't proceed. Everybody has now the approved cap in front of them, so it's certainly no secret where those lines are. We have a lot of comments from people who are seeing that they just clip their corner, and they're really happy about that. So. Okay. That's all I've got on that subject. Does that give us enough to move forward? And I'm hopeful that we can get our regulations lined out here next couple months. Okay. Laramie growth area, what's the update on that? Not the least bit hopeful we're gonna get that sorted out in the next couple of months.
Yeah, so Mr. Chair, Commissioners, the Laramie growth plan has been published, and we have a public hearing before the Board of County Commissioners at their meeting next Tuesday, which is July 8th. It's a night meeting, so 6 o'clock, so everybody to come. And then that's approved at that point. The City Council will have it on their agenda on August 1st. And then if it's approved there, then we have a joint plan. And then we'll be proceeding in a similar manner as this. We'll start looking at regulations and
Intergovernmental agreement, that's not part of what's being approved.
No. Okay. That all comes after the plan, so yeah. That's where we're at. So at this point, we have not received any comments for the Laramie growth plan, so.
Is there a gap in written comments for the public hearing?
Yes, they were supposed to come in by today. Oh, so. Where was it? Was it today? I think it was Wednesday, yeah. So, and I will note that there was not a single public comment during either of the public hearings for the cap. There was a few written comments, but they were like, good job, we appreciate this. But there was no comments in either public hearings.
What is your expectation? Is this, we get to the intergovernmental agreement and all that annexation, I would think that's a hornet's nest, no?
Oh, yeah.
Okay. Just wondering whether I should wear my armor or not.
Yeah.
IGA, I mean, that's not a public.
That doesn't necessarily have to come.
That's contract.
Yeah, it's a contract, so.
So we will see it as a zoning resolution thing.
Well, yeah.
The
implementation of.
Oh, yes.
Yes.
Yeah.
There'll be another overlay.
Okay. Questions on the growth plan? Okay. Games begin. Our next regular meeting, August 9, 5 o'clock here. Comments on general matters by the commissioners. We've heard ourselves out, run ourselves out, played ourselves out.
Maybe you cast this comment already.
Go right ahead.
I just wonder if the city could be leveraged into participating in an amicus brief on the lawsuit that you're dealing with right now.
Well,
Where the city work to defend the county reg changes for the APOZ because it impacts their wells. So it just seems like having an amicus brief by the city, if that's what you call it.
It is.
Would be a good thing for the city to do. And can they be encouraged, like how would they be encouraged to participate?
You could ask him. That's about it. Depends on how they would do that. Like if they're hiring outside counsel, yeah, I would think they would need to, but
If someone was interested in that, they could contact the city, however they felt was fine.
yeah.
All right, you're doing your thing. Okay, fair enough. We've worn out the citizenry pretty thoroughly.
I do have a.
Yes,
As a citizen attorney. Anything with the fencing stuff, again, that is in play now. We have to start requiring that of new subdivision permit applications regardless of our regs. So I think it's always good to get stuff on the books as soon as we can, lest it lapse. So if anyone had any ideas on the wildlife fencing, I just ask that those not get forgotten.
I know Commissioner Van David has been looking into that.
Okay.
Some care and talking to Game Fish, look at their design
Oh,
manuals.
wonderful.
So the short discussion I had with her was, I'm not sure that's relevant. The state statute, for whatever reason, was pretty darn specific. 3 wires, barbs.
Yeah, but we have that, it's still that minimum requirement. So we can say this is what you have to do because it's designed to stop, because there are the 2 ways that you can do it, and then there's the effective at preventing stock breach
If you can
standard.
demonstrate that it fulfills that, keeping the cows in.
Yeah, and we would just say this is what is demonstrated to.
So yeah, she's
Okay.
been working on that, which I applauded, and where I think we're all sympathetic to is let's find something other than what they require. So yeah, good point. All right. Absent any objections, going once, going twice, we are adjourned. Thank you as always for your patience. We always seem to cover more ground than we thought, but I think it's a good purpose.